list, matter fixed for 10:30, item number 84.
Yes, yes.
May I please your lordship?
DAV school.
My lord, I'll just, with your lordship's kind permission, first I will take your lordship to your lordship's order dated 14/7/2000.
No. Before that, the school building is over.
No. Nothing has been done. Only they were uprooting the trees when your lordship has been pleased to pass the order. I'll only demonstrate with reference to the pleadings and the provisions.
Okay.
If I can prima facie satisfy your lordship
Right.
that there has been no proceeding at all
Okay.
with regard to de-reservation, certainly the entire thing will crumble.
All right.
And if I don't satisfy that to your lordship, my lord, I have to fail. And that is the point.
Right.
For that purpose, with your lordship's kind permission, may I just read out order dated 14/7/2022, because your lordship has been pleased to record the crux of the matter in this order, my lord. Your lordship will see, and the state was called upon to, my lord, file affidavit on that, and whether they have satisfied or not. May I just, with your lordship's permission, place it, my lord. A rejoinder affidavit has been filed by the petitioners in reply to the counter affidavit filed by the Tahsildar Puri, enclosing an extract of revenue record number so and so. I am skipping it, my lord. Having Kisam Gochar as well as plot number 1973, measuring so and so, which were originally having Kisam Gochar in 1927. Learned counsel appearing for the petitioner state that in the counter affidavit filed by the Tahsildar, although it has been clarified that there has no alienation of plot number 1971 is contemplated, it appears that land to an extent of 5 acres from out of plot number 1973 was alienated in favor of IDCO. He submits that circumstances under such alienation took place and the further alienation in favor of DAV school took place have not been mentioned in reply affidavit of the Tahsildar. He also questions, and this is very relevant, he also questions if the procedure required for converting the Kisam from Gochar to Bagat as indicated in Annexure 1 to the petition has been followed. Mr. D.K. Mohanty, additional government advocate, says that all the relevant records are available with the government. He undertakes to file a supplementary affidavit of the Tahsildar enclosing all relevant records, which would indicate what the Kisam of plot number 1973 originally was and whether it has been changed subsequently to Bagat in accordance with law. This is very relevant, my lord. Counsel appearing for the IDCO that your lordship may skip. Then, my lord, your lordship was pleased to confine it to 1973. So it is to be seen as to whether, because in the PIL, my lord, in the writ petition itself, my specific contention, your lordship see that there is no denying of the fact that in order to de-reserve a land which is Gochar in nature, the provisions of OGLS Act, more particularly 3A thereof, has to be followed. It cannot be done under the Consolidation Act by changing the Kisam of the land in question. This is what I beg to submit, and my learned senior appearing for the state, I hope will not dispute this legal proposition. So, bereft of what will be the, my lord, factual aspect of the matter. Now, your lordship may kindly turn to the Orissa Government Land Settlement Act.
Section 3A.
Section 3A. May I present it, my lord?
Yes.
The government may, by notification in the official gazette, authorize any officer not below the rank of a collector to de-reserve any land which has been reserved under clause A of section 3 or any government land recorded as Gochar or any portion thereof. Any officer authorized under subsection 1 shall, subject to such conditions and limitations as may be prescribed, have power to de-reserve any land referred to in that subsection or any portion thereof, if such officer is satisfied, such land or portion thereof, as the case may be, is no longer required for the purpose for which it was reserved, or can no longer serve the purpose for which it was reserved, or is in excess of the reasonable requirement for the purpose of which it was reserved, provided that the officer so authorized shall, in assessing the reasonable requirement for the purpose of Gochar, follow the prescribed principle laying down the extent of Gochar land to be set apart for use of the community. So therefore, what is to be done? The satisfaction is to be recorded, and it is only not an officer below the rank of collector. So I'll show from record whether it has been done or not. Now they say as per the prescribed procedure. Procedure has been enumerated in rule. Your lordship will see rule 3, rule 4. I'll not place the entire provision. I'll only place few portion of it, my lord. Rule 4, the procedure, the modalities for the reservation has been spelled out. Any land, may I place it, ma'am?
Yes.
Any land which has been reserved under clause A of subsection 1 of section 3. I'm sorry, madam.
This is rule 4 of the 83 rules.
Orissa Government Land Settlement Rule 1983, Your Lordship.
Yeah, that's right. That's it. I have.
So here I will not place it in extent. So I only beg to submit. There has to be a public notice.
Right.
Because the 3A says the modality is provided to be provided. And modality is under Rule 4. There has to be a public notice.
Correct.
Now, so far as this petition, main PIL petition is concerned, Your Lordship, I beg to draw Your Lordship's kind attention to page 6, paragraph 6. I have said that none has been had, now notice has been served. Then, in ground number 2, I have specifically stated that the provisions of OGLS Act has not been followed. Your Lordship will kindly find so far the PIL is concerned.
The counter. Let's see the counter.
Now, the first counter affidavit was filed on 5/5/2022. Therein, they clarified that 1971 has not been alienated. So, Your Lordship was pleased to confine the interim order to 1973 only. Now, I filed a rejoinder affidavit to this counter affidavit, but this will not be relevant. The subsequent affidavit will be relevant. In the rejoinder affidavit, I showed to Your Lordship that the land in question is Gochar. Your Lordship, though the annexure is in Moria, Your Lordship may pardon me, but page 4 of 5th column, it is mentioned as Gochar, which was taken note of by Your Lordship in order dated 14/7/2022. And that is why Your Lordship was pleased to ask the State Council to file.
Yeah. So 11th August affidavit.
That is important.
We place it. I'm placing it. I'm not shying away from that. So in 11th August affidavit, it is to be seen whether the provisions of OGLS Act. I beg to clarify one thing, my lord. What they have filed is a change of kisam during the consolidation operation. My humble submission would be that in the absence of mandated provision with regard to OGLS Act for de-reservation, but the requirement and everything has been spelled out in 3 clauses. Mere change of kisam will not clause the right to transfer. Because they have made a statute, they are bound by the statute. They have made the statute and they have said it has to be done this way. So merely, and I'll show the fallacy on the face of it. One piece of paper in the additional affidavit and 11/8/2022, they say we have
Let's read that.
taken the right. Your Lordship may kindly see 11/8 affidavit, page 2, paragraph 3. They have quoted Your Lordship's order being conscious of that. Now, I beg to place this. May I place it? As directed by this noble court, it is respectfully submitted that during the year 1977, the land in question was under Sabic plot number 1364, measuring an area of 30 acres 65 decimals, having Gochar Kisam in Rokhit Khata, Onavadi Khata number 1161 in village Samanga. Now, Your Lordship will see.
No, let's read on.
Next.
I'll read out, ma'am. I'll read out everything. I'll read out in extent. So I wanted to place up to paragraph 8. I'll place it. During the consultation operation, which commenced in the year 1989 and culminated with publication of record of rights in the 1415, the land in question bearing Sabic plot number 1364 was recorded as plot number 1973, having same area with Bogai 3 Kisam in Rocky Khata number 3206. The same would be evident from the report of the additional sub-collector, Consultation Puri, contained in letter number so-and-so, a copy of which is filed herewith as annexure A/6. I will draw Your Lordship's kind attention to annexure A/6, but before that I will place 6 and 7. A perusal of the said report reveals that the Amin had conducted a field inspection over the plot and recorded as follows. This is version of the ODIA. It reveals that plot number 1364 is in Kisam Gochar in Sabic record. However, over the said plot, some jhaung plants. Now, my contention that it was government had entered into an agreement with the committee for developing jhaung plants gets fortified from this. Some jhaung plants were planted by the government. The map and area of the land plot are intact as per the field report. Then next paragraph, the Assistant Conservation Officer Gorul Camp passed order dated 24/6/91 to record the said Bogayat plot, a said plot as Bogayat 3 Kisam in Rokhit Khata. Pursuant to the said order, final record of right has published.
Yeah, so this is the crucial change.
My lord, your lordship may now
Assistant Consolidation Officer passes an order on 24th June, simply saying, now let's call this Bagayat.
and was there a report to that effect? That is what I will beg out.
No,
I
so
beg to.
he says on the basis of that above report, because
My
now
also,
plants are now there in that plot, he says now let's call it Bagayat.
your lordship will see page 8. This is the document which they say takes away the right of the communal land of the inhabitants of the locality from Gochar to Bagayat. Can this document take away? That is what I beg to point out in law. Before that, page 7, your lordship may kindly see, though this is in Orissa, your lordship will find the plot in question was Gochar in 1927-28, so in 1977 record. Only in 2014-15 this has been made Bagayat. On the basis of what? This is annexure page 8, your lordship. Page 8 is the basis. Entire case hinges upon page 8, my lord. Page 8, your lordship will see, there has been lot of, my lord, corrections, erasures. I'll leave aside that. I'm not on that. But what was the recommendation? Your lordship will see in the left-hand side, Gochar. Again, your lordship may kindly see. That means the Amin report shows it is Gochar. Till as on the date when this report was given to the SA for the purpose of either changing or whatever it is. Now, what he recommends also, in the left-hand side, he has given a noting. I'm reading it in Oriya, then I'll translate it in English for your lordship's kind appreciation. Mahasaya, plot number 1364, measuring so and so, Sabak mate record kayam rakhiba nimante jonaili. That means I report that it should be confirmed as per Sabak record. That is what is the report of the Amin. That means as Gochar. Because page 7 shows their own document that it was Gochar in 1977, 27, 28, which is Sabak record. So therefore, he recommends that this is still Gochar and please record it as Gochar. Now on the right hand side, the ASO gives a remark that this is recorded as Bagayat. And this is not in accordance with a dereservation proceeding. I give emphasis upon the fact that a consultation authority cannot take away Gochar land on the basis of that. Now, my learned senior on the previous day was submitting that a challenge has been made belatedly. I am not challenging this record at all. My contention is that the provisions of OGLS Act has not been followed. So therefore, this consultation authority making it Bagayat or anything doesn't make any difference, because unless they de-reserve the land in accordance with the law, finding out as to whether there has been adequate land or not and how much is to be kept apart and all the other two components which I have placed, question of assuming a right on the basis of this, or for that matter, transferring it in favor of the IDCO doesn't arise. Because OGLS Act also provides.
When did this document become public? Never became public.
No, there is no notice, nothing. And they don't say in their affidavit, my lord, that there was a notice to change the Kisam from Gochar, because Gochar is a communal land, your lordship. So every inhabitant of the locality has a right. And here I have shown one document under Annexure 2 to my PIL, where the government has entered into an agreement with us, a committee headed by petitioner number 4, to develop Jhaun Jungle there. And this affidavit also fortifies my stand, where they have said there is existence of Jhaun Jungle. That is what the affidavit of 11.8 says. I beg to again draw your lordship's kind attention to page 3 of the affidavit, paragraph 6. So therefore, in the absence, my lord, this piece of document, there is no order, nothing. And the inquiry, the Amin who was sent for inquiry, he says it should be recorded as for Sabik record. And the consultation officer doesn't assign any reason why it should be Bagayat.
No. When did you get activated? Because one argument when we advanced this, what were you doing all these years?
My lord, I got to know only when they tried to remove the Jhaun Jungle, because we are taking care of it. I stated in my PIL. So we applied under RTI Act. It came out in paper, newspaper, that is Annexure 4 at page 29. When it came out in newspaper that this has been allotted to DAV, my lord, that is newspaper I will show to your lordship, my lord. It is not that, my lord, I have not taken steps. I represent, this is Annexure 4, page 29.
So Annexure 5, you gave a representation.
I gave a representation. I applied under RTI Act also. When I applied under RTI Act, this information at page 34 came into existence. So thereafter, my lord, so therefore, the public has been kept in dark, and there is nothing in affidavit of 11.8 showing that there was a public notice. And in any event, probably the authorities have forgotten the there are two components, namely, first government de-reserving it, then alienating it, and then it goes to DAV. Now, so far as from IDCO to DAV is concerned, possibly I will not have any grievance with regard to that, because if at all the alienation by the government to IDCO survives in terms of the provisions they have enumerated, my lord. So if your lordship holds, and that, my lord, the government assuming right to transfer will have two components, namely, first de-reserving it from Gochor to normal, then alienating it in terms of that OGLS Act. OGLS Act also provides for alienation, no denying of that fact. But the modalities have been spelled out. And you have made a legislature, you have made a statute. You have to be bound by it. That's all, my lord. And you have said not below the rank of collector. He is an additional sub-collector. Even assuming he can do it. Even assuming he can also, he will not hear anybody. Though the statute mandates that the hearing is mandatory. That's what has been spelled out, my lord. So this is my humble submission for your lordship's kind consideration, my lord.
May I please, your lordship? I will draw your lordship's attention to page 10, annexure 1. This is the consolidation record of right published in the year 2014. And the suit land is 1973, recorded as Bogayat Kisam. Yes, there is no dispute in it. So your lordship knows it very well, but still I want to confirm your lordship that there is a lot of difference between Survey and Settlement Act, the ROR published under the Survey and Settlement Act, and the ROR published under the Consolidation Act. Consolidation Act, right, title, interest, everything is finally published, finally decided, and everything is that has got more legal strength than, because any ROR under the Survey and Settlement Act, it neither creates title nor extinguishes the same. But so far as Consolidation Act is concerned, your lordship knows various full bench decisions of this honorable court. There is a legal strength of that. This is the latest Consolidation Act, Potta of right of 2014, in which the Kisam was Bogayat. Now, question arises that previously it was in the Sabik record 1927, it was Gochar. Question now arising that how it became Bogayat in the consolidation. In explanation, I have given in my counter affidavit that during the consolidation operation, the report my learned friend has submitted at page 8. Yes, I also admit that is a very important, that is Amin report. The left-hand side, he has indicated Mahasaya, plot number so-and-so, Sabak Mate, the records to the Sabik records. That means the RI has referred the Sabik record of right and accordingly request or prayed the authority that the right title interest should be in favor of the Rakhit Khata, in favor of the government, so far as the HAL record of right is concerned. But the right-hand side column, it is clearly noted that the Bogayat Kisam, the change of Kisam is...
How?
Yes, that is what I am saying. So it is a case where we find that during the consolidation operation, the consolidation officer has changed the Kisam to Bogayat from, and accordingly the consequences...
Point number one, does he have the power to do that? And has he followed the procedure for doing that?
Let me submit to your lordship that this is the infrastructure of the consolidation record of right, annexure 1, that he has converted. Now, this record of right is final and conclusive, and if somebody is aggrieved by this record of right, section 37 gives enough power to them to challenge that record.
You can't, because this has remained hidden. See, the point is
it is public domain. It is in the public domain.
Not that you can simply walk into an office and ask. It never happens like that.
It is nothing to be like that. It is in the public domain.
Unless you file an RTI, you never get to these facts.
No, it is available. Anyway,
in fact, only with your additional affidavit, all the substance is enclosed. Because we pass a specific order and then you undertook to place and record all the relevant documents that it has come out.
Now, because we have also mentioned, your lordship may kindly see in our counter affidavit.
Mr. Mohanty, what does it entail? 1 month's delay, 2 months delay? Even now, it's not late for you to follow the procedure.
Under the OGLS.
Do it.
What cannot?
That's why I asked him, have they started?
I humbly pray your lordship that now, as on date, we cannot, because the record of right is already on in the Kisam Bogayat.
After the judgment, we will say that it's put back, the clock will be put back to the place of this ASO or whoever, additional sub-collector.
24/6/1991, order dated.
By whom? What is the decision? of
Additional sub-collector, they say.
assistant consultation officer.
since he has no power to simply convert a land to bagayat, suppose we set aside this and say that if clock is put back, we will treat it as gochar land and follow the procedure now. And you may be able to convert it properly. Once you convert it properly, then he will have no objection left.
And they are also subject to our objection, they will decide whether they should
Because-
convert or not.
Correct.
Your lordship may say, because we have
they have to hear.
substantially progressed.
What is that? That's why I asked him also.
We have already leased out the land to IDCO.
No. Has any construction actually started?
No.
Construction has not yet been commenced. He is appearing for
So the land is
ASO.
remaining as land. What I'm saying is the land is as such as there as land. You may only have to follow the procedure. It happens very often. When the Kisam is jungle and you have to convert it to something, Kisam is gochar and you have to convert it to something.
And here also the forest rule will come into picture, because as per their own version, it is Jhaun. They have to take permission of the central government as per their own rule. That I have not contended. That's also a point, my lord.
No, but all I'm saying is all these procedural requirements mean, let's say 2 months time will take 3 months, even probably 6 months, but it's only a procedure to be followed.
One more thing
But
is,
subsequent actions may not be invalidated because we have already
How
received.
can you? Can't. No, the land is land. The nature of the land
But
is
I
what it
going to
is.
Your lordship may kindly understand my point.
Ah.
We have already received a lump sum amount. The IDCO has deposited. These are all the things prospectively we have done. And now if the
No, is it irreversible is the question. It's not irreversible. It will all be put on hold. What I'm saying is you will not return till you complete this procedure. If at the end procedure, you are in fact able to convert gochar to bagayat.
and that
that's the end of the-
direction can be issued to state
Have it,
government.
yeah.
But keeping intact the prospective actions to
No,
invalid.
till it's complete. At the end of that whole procedure, suppose you are unable to convert to bagayat, you will return the money.
yes. One more thing I was just pointing out, even by operation of statute, the transaction is void. But they say it's Jhaun, that means it's a forest land. Orissa communal forest and
No,
private
I'm
land.
saying we are not concerned with the deposit of that money and
Rule
all that.
3,
Ha,
Rule 4
they
said
can
it
take
is
a call
void.
on that. Yeah, they can take a call.
There is a provision, my lord,
Huh.
under the OCH Act, consolidation section 8, subclause 4.
Huh.
In this OGLS Act, shall apply to lands required to be earmarked for public purposes as aforesaid. Kindly see section 8, subclause 4.
Rule or section?
OC Act. Oh, Consolidation Act, my lord.
Consolidation.
Yes, my lord. Consolidation. The book is here.
No, we'll have. Consolidation Act is plus. No, but this land is governed by the OGLS Act.
No. OGLS Act is not applicable. That is the proviso clause. The OGLS Act is not applicable where the land is required to be earmarked for public purpose. That your lordship may see the.
But that is what I am saying. It's not purpose, it's there. Now they are de-reserving. So therefore, it is not applicable anything required for public purpose. So what they are saying, they are transferring to a private individual by de-reserving
It is also
So these provisions they cannot
school
take
is-
care of.
Establishment of a school is for public, not for me or somebody else.
Government
DAV
school is
school
one
is going to be established. You are saying that it is.
Government school is one thing. It's a private school.
No, it is given to IDCO. IDCO in turn has given to
Whatever.
maybe a private school, but all the beneficiaries are all public at large.
And my lord, in terms of Vrindavan Sharma case, this order is a void order, my lord. They have said order without authority is a void order, my lord. It has to be ignored at any stage.
Section 8, subclause 4. Has your lordship got it?
Yes.
Yes. This contention may be recorded.
Yes.
Should I take instruction as to whether whether it is earmarked for public purpose? Or
That is Gochar, my lord.
What is that earmarking? That is the point. What is that earmarking?
But that is earmarking is, my lord, I will say humbly submit Gochar. That's for public purpose. That's a communal purpose.
If it was, I think his argument is if it was continuous gochar land, then OGLS Act will not apply.
Yes,
but
exactly.
The
your lordship.
minute you start converting that gochar to some non-gochar,
Right.
then OGLS will apply. That's what it means. You will not even bring that Gochar land into the consolidation operation.
Yes.
See, when you look into a village, these are Gochar lands, they will not be pulled in for that consolidation operation.
That is the normal procedure as far as my knowledge.
Yeah. Even in
For-
Punjab,
It's only
For agricultural land. That is yes. That is
Correct,
correct. That is correct.
I must say, you don't leave any stone unturned in your arguments.
And I find it very difficult also to stand against the land senior.
My respectful submission, the predicament is that we have substantially progressed. Money has been deposited. Everything is done. Now at the last stage, they have never raised any objection at the relevant time. The was published, record of right was published in 2014. Now,
I must say, these villagers seem to be vigilant. Once the Jao was being removed, then they must have realized something is happening.
Yes, man.
That's what has happened. All right.
Only my prayer would be that whatever your lordship is directing, we will comply that Gochar process under the. But the subsequent actions.
No, that is up to you. See, you decide on those things. See, we are not concerned with that.
So no negative finding may be
It's
given.
between-
That's all.
No, it's between ITCO, the party, you, all of that.
IDCO
What
is
should
there
happen?
also. IDCO is also there.
I'll just clarify one thing.
Demand
Suppose hypothetically, they decide, no, it is not, it cannot be de-reserved, because that is one thing.
No, then they'll have to reverse those.
So therefore, my
rules.
learned senior saying that it should be saved the constitutional actions.
Two things can happen.
Yes.
What you're now anticipating could happen, in which case everything gets reversed.
And if they say that,
But if they succeed in converting it to Bagayat, there's no need. Then they just continue from where
so
they
they
left off.
have a frame of mind that we'll do it this way.
No, not frame of mind.
Yes.
No, that is not the frame of mind.
Because
Subject to result of
Because
the
it is-
OGLS process.
they are also statutory authorities. They are also judicious in terms of adjudication under a statute.
Right.
We are always.
Well, so far as land has already been allotted since 11/1/2021, and demand was raised before DAV, and DAV has also
Correct.
paid
All that has happened.
92 lakhs.
Nobody's denying all that. Nobody's
Well,
denying.
Now, these are to be, I only pray that these are to be recorded in the order, that these are the developments.
Yeah.
As on date.
Four villages of village Golasahi, PO Khadipada, PS Puri Sadar, District Puri, have come together to file the present petition, questioning the transfer of Anabadi land having Kisam bracket a single Gochar pertaining to plots 1362, 1364 under Khata number 1161 in Moza, Samanga, corresponding to consolidation plot number 1973, measuring AC 30.65 decimal, having Kisam Jao under Khata number 3206 for construction of a private school. Paragraph. According to the petitioners, without following the procedure outlined under the Orissa Government Land Settlement Act 1962 bracket OGLS Act, read with the OGLS rules 1983, the land in question in plot 1973, which was shown as single quotes Gochar, which was having Kisam Gochar in the government records, had been alienated first in favor of IDCO, bracket opposite party number 8, which in turn has handed over the land to opposite party number 9, that is the DAV institutions, which have proposed to construct a school on the plot of land. Paragraph. Initially, this court had issued notice in the case on 19 January 2022 Full stop. Subsequently, when it was noticed by the petitioners that steps had already been initiated by opposite party number 9 to commence construction, they filed IA number 4905/2022, in which on 20th April 2022, this court inter alia passed the following order. Just take para 3 of the said order. Paragraph. At a subsequent hearing, when a counter affidavit had already been filed, to which a rejoinder had been filed with the petitioners, this court on 14th July 2022 passed the following order. Reproduce the entire order. 42. Paragraph. Pursuant to the above order of this court, an additional affidavit has been filed by the Tahsildar Puri, where after setting out the direction issued by this court in its order dated 14 July 2022, it is stated as under. Take paras 4. Nine. Paragraph. It is claimed that thereafter a spot visit was conducted by the Tahsildar along with the revenue inspector. Bracket RI, bracket Sasan Damodarpur. And then records were put up before the collector Puri, who sanctioned the lease of an area of AC 5.00 decibel out of an area of AC 30.65 decibel from plot number 1973, Khata number 3206. Full stop. Following this, an agreement was executed between the collector Puri and IDCO under the Odisha Industrial Infrastructure Development Corporation Act 1980. Registered on 30th December 2020. Full stop. It is thereafter that the record of rights, bracket ROR, for the above land was mutated in favor of IDCO. It is maintained that at the time of alienation of the land in favor of IDCO, the kism of the land was already, single quotes, Bagayat-3 and not Gochar. And therefore, the provisions of the OGLS Act vis-a-vis Gochar land are not attracted at all. Full stop. It is therefore no Gochar land has been allotted in favor of the DVV management whatsoever. Paragraph. Mr. Samir Mishra, and counsel appearing for the petitioner, has drawn attention of the court to the fact that both in para 6 as well as ground number 4 of the writ petition, a specific government, ground number 2 of the writ petition, a specific government was made that the opposite parties had not followed the provisions of the OGLS Act while converting the kisam of the land in question from Gochar to Bagayat-3. Stop. He has drawn attention to section 3 capital A.
That is rule 3A. But that will be de-reserving, not converting, de-reserving.
Without de-reserving. Yeah,
Right.
all right. He's drawn attention to section 3 capital A of the OGLS Act and the procedure outlined under rule 4 of the OGLS rules, which required a public notice, invitation of objections before de-reserving the Gochar land. Stop. He points out that in the replies filed thus far, there is no denial of this averment of the petitioners. Full stop. However, what is sought to be weighed by the opposite party state is that sometime in 1971,
91.
no, sometime in 1991, on the noting of an assistant sub-collector, or is it sub-collector?
It should be
Assistant
SEO.
consolidation officer.
Consolidation.
My senior says ASO, but it should be
Sorry,
SEO.
sorry.
Assistant consolidation officer bracket ACO.
I said so. Sorry.
And noting was made in the relevant record that the kism of the land in question should be recorded as Bagayat. Paragraph. Mr. D.K. Manti learned AGA also refers to the same additional affidavit of the Tahsildar and states that indeed the ACO had made a noting way back in 1991 that the kism of the land should be recorded as Bagayat. And on that basis, the ROR also reflected the change consistently thereafter. Full stop. He drew attention to the fact that as of 2014-15 itself, the kism of the land was continued to be reflected as single quotes Bagayat. Stop. He submits that since these documents were in the public domain, all the authorities acted on that basis, and matters have progressed much ahead, with the lease being granted first in favor of IDCO and alienation of the land then taking place in favor of opposite party number 9, with IDCO having deposited monies with the government, and in turn, the DV institutions having deposited monies with IDCO.
Yes.
He accordingly praised that at this stage, the court ought not to interfere, as it would cause great inconvenience to all the parties. Full stop. Paragraph. The submissions of Mr. Manti have been supported both by counsel for IDCO as well as counsel appearing for opposite party number 9. Paragraph. The undeniable fact is that till 1991, when the above noting in the relevant record was made by the ACO, the kism of the land in question was continued to be shown as single quotes Kochar. Stop. In fact, in the same record in which the above noting was made by the ACO, on the left-hand portion of the relevant page, the what is his name? Amin.
But it was observed that it should be recorded as per the Sabik record. That means Gochar.
No. That the RI has reported that the Sabik Mutabak record kora jau. That means according to the Sabik, whatever the right title interest, that should follow. So far as Kisom is concerned, there is no special noting. No, it is there. Your Lordship can.
But their own document at page 7, it says Sabik is Gochar.
There is a lot of difference between right title interest recording with relate to regarding right title interest recording regarding Kisom. So far as Kisom is concerned, it is separately dealt with by the concerned officer in the right hand side.
The Amin had recommended that the
Sabik
record should be adhered to.
Yes, that's all.
The fact remains that till then, the kism of the land had not been changed. Paragraph. The further undeniable fact is that the only procedure for dereserving a Gochar land is that which is set out in Section 3, capital A of the OGLS Act, read with Rule 4 of the OGLS rules. Stop. It does appear that this procedure was not followed in the process, as it is not even the case of the state that any public notice as required thereunder was issued, inviting objections. However, Mr. Monti, learned AG, drew attention to Section 8, subsection bracket 4 of the Odisha Consolidation of Holding and Prevention of Fragmentation of Lands Act, 1972, bracket OCHPFL Act, bracket, which states that nothing contained in the OG-less Act would apply, shall apply, open quotation, to lands required to be earmarked for public purposes as aforesaid, unquote. The above provision, full stop here, he sought to contend that since the running of a school was a single quote's public purpose, unquote, the provisions of the OG-less Act would not apply to the land in question. Paragraph. The court is unable to agree with the above submission. Section 8, bracket 4 would apply in a situation where the land in question is a gochar land, which has already been earmarked for a public purpose or any such land. And it is such land which will not be governed by the OCH-PFL Act. Full stop. In the present case, however, with the dereservation happening, this argument would not apply. Full stop. What is relevant to note, however, is that the dereservation has happened without following the procedure under the OG-less Act. Paragraph. The fallback argument of Mr. Mohanty was regarding latches and even as late as 2014-15. And with the ROR being in the public domain, the petitioners have approached the court very late for asserting their rights. Full stop. Paragraph. The court is not impressed with this argument.
The alternative remedy is available under section 37 of this.
He also submitted
in which no limitation is prescribed.
All right.
After 30 years
If
also,
the petitioners were aggrieved by the order passed by the ACO
and the consequential record of right,
as well as the consequential ROR, then they could avail of the statutory remedy of an appeal under section 37
of OCH
of the OCH and PFL Act. Paragraph. The court is not impressed with the motion. Full stop. It is only when steps were started to be taken by opposite party number 9 to remove the jamun plants on the land in question that the villagers got alerted to the fact that some alienation had probably had taken place of the land in question. Full stop. They immediately filed a representation with the authorities and followed it up with making application to the RTI Act without wasting much time. Full stop. The copy of the information received by them, the RTI Act, sometime in December 2021, has been enclosed as Annexure 6. Full stop. It is thereafter that the present petition was filed on 11 January 2022 without wasting any time. Consequently, it cannot be said that the present petition is barred by delay and latches. Paragraph. The sum total of the above discussion is that the dereservation of the land in question, which was Gochar land, to single quotes Bagayat 3, has happened without following the procedure outlined under the section 3 capital A of the OG-less Act, read with rule 4 of the OGLS rules. Full stop. This illegality is not a curable one as far as the validity of the subsequent actions of alienation of the land in question in favor of ITCO and the subsequent handing over of the land in favor of opposite party number 9 is concerned. Full stop. That will be the inevitable legal result of the finding of this court that the procedure for dereservation of the land in question was not followed. Paragraph. The question then arises as to what should happen hereafter. Full stop. The authorities would now take steps in terms of section 3 capital A, read with rule 4 of the OGLS rules, of the OGLS Act, read with rule 4 of the OGLS rules, by treating the noting by the ACO in the relevant record that the kism of the land should be recorded as Bagayat 3 as invalid and honest, Full stop. As a result, the status quo ante, that noting of the SCO in the revenue record, will come into being, in which case the land in question will be treated as of now as Gochar land. Full stop. Steps will now be taken, therefore, under Section 3 capital A, read with Rule 4 of the OGLS Act, read with Rule 4 of the OGLS rules, for de-reserving of the Gochar land in accordance with, full stop, if there is any other legal requirement to be complied with in connection with the land in question prior to its alienation in favor of IDCO, then that procedure will also be complied with by the state authorities. If at the end of all of that procedure, the land is in fact de-reserved and is no longer Gochar land, then further steps will be taken by the state authorities and opposite parties 8 and 9 in a court. Full stop. If, however, the land continues to remain as Gochar at the end of the entire exercise, then obviously the steps taken would have to be reversed. Thus far would have to be reversed. Full stop. The court expects that the steps to comply with the procedures for de-reservation in accordance with law would be completed in the time-bound manner.
Within 2 months.
Yeah, in a time-bound manner.
Madam, we were 2 months. They may be in a hurry.
Right.
Time-bound, man.
Time-bound.
Deeply obliged.
May I submit one thing?
Ah.
And subject to result of the OGLS proceeding, the subsequent actions will.
Madam has clarified.
I've said that. I've already said that.
That is
Both ways.
Yeah, it has been said.
If it goes, everything will be invalidated. If it remains, then
that is obvious.
deeply obliged.
And this we will only initiate the delivery proceeding for these 5 acres.
Yeah,
of
it is
land.
made clear till the procedure is complete. The status quo as of today will be maintained.
Deeply.
Yes, that is there.
Now,
That
will your
we-
lordship only take note of the fact that 1971 they filed in the affidavit saying that no action is
No,
being
that
taken.
order
that
has
is
been
already
reproduced.
there. That
So
is already
that
there.
will come.
That is already there.
All right, all right.
Obliged.
Supplementary list, old matter, item number 1.
May it please, my lord. I was going through the brief, my lords. I have come to, I see that an appeal is provided. I am to prefer an appeal under section 7(1).
All right.
7I, sorry, 7I.
All right.
I may be permitted.
All right. Counsel for the senior counsel for the appellant seeks leave to withdraw the present appeal with liberty to prefer the actually of an appeal as provided under the.
May I pray, my lord? I am for the employees. I am intervening. And the only case is getting block grant, they will not pay EPF. Government has clarified. I have filed the document with my.
That will be decided there.
I am not saying. My friend, you have time limit for dispatch because.
Yes,
they are not
Ah,
getting
yeah,
money.
yes.
They can't tell.
No, under section 7(1) of what act?
7I.
Appeal provision is there. Sensitive provision fund act.
Of the Employees Provident Fund Act.
Yes.
That is time limit for disposal of the appeal.
That is EPF and MP Act.
EPF and I.
I pay for a time limit for disposal of the appeal because it is due
If
to
such appeal is 1 minute, sir. Such appeal is preferred not later than 12th December 2022, accompanied by an application for condonation of delay, explaining the delay on account of pendency of both the writ petition as well as the writ appeal. Then such delay will be then it will be considered in accordance with law by the appellate authority. Full stop. The court clarifies it is not expressed any view on merits. The authority will then, the appellate authority will then endeavor to dispose of such appeal within a period of 4 months thereafter.
The order of stay may be vacated, my lord.
The appeal is disposed of as withdrawn in the above terms with the liberty as prayed
To
for.
move therefore interim order. Yes.
All right.
Supplementary item number 2.
May I please your lordship? My lord, the impugned order of the Lord and Civil Judge is at PS 16, my lord. Your lordship kindly see the order passed by the Lord and Civil Judge, my lord. Paragraph 2, my lord. Looking to the prayer number 1, this court finds this prayer involves a direction to the opposite part number 1 and 1 to 3 to reconstitute the case record in OLR case number 596 by 80 and grant a certified copy of the order of settlement of the land in the name of the petitioner. London State Council on instruction submits that the case record is no more available, for which there is no possibility for reconstitution of the case record at this stage. Under the circumstances, this court finds no relief can be granted at this stage, but however, this court disposed of the petition recording the submission of the London State Council as indicated herein above. In view of the disposal of the petition, interim order passed earlier stands vacated and all the pending cases arising out of this petition stand disposed of accordingly. My lord, the petitioner's father is a settled lawyer and who has been settled on section 4(2) of the OLR Act, my lord, by the London Tahsildar Puri. And thereafter, my lord, he has paid the salami and rent. And when he applied to record his name, mutate his name in his favor, my lord,
are there any dates for these things, sir?
My lord, your lord. My
Are
lord,
there any dates when the petitioner's father applied, when the record was mutated? Are there dates for these things?
My lord, I'm submitting before my lord. There is admission that the case record is there and it has been.
Sir, can you tell us?
Not
Can you kindly tell us the dates, sir?
Dates, my lord, the 80. The case was filed in the year 80, my lord. 596.
When somebody asks me date and I simply say 1980, is that correct answer, sir?
That is not the order. Particular date is not available.
Why not, sir?
But that was not supplied to me, my lord.
Then we are not unable to help you, sir.
My lord, your lordship.
If you are going to be so casual about the facts, we are unable to help you, sir.
But it was pleaded, my lord. My lord, it was your lordship kindly collector has admitted that the case record is there, but it has been lost. And your lordship kindly sees the page 7.
Sir, when somebody tells me case record is there and it is lost, what should I infer, sir?
My lord,
that it is there or it is lost?
My lord, the poor petitioner will suffer. He is the settled earth, my lord.
Without a record, without there being a record, what can we do, sir? Tell us.
And he has paid your lordship kindly fine. He has paid the rent and also salami as per Annexure 2 series and 3 series, my lord.
Once you say they are acted against an order dated 5th October 2016, passed by the London single judge dismissing the appellants. Writ petition civil OGC number 8885 of 2000. Full stop. It appears that appellant claiming that the suit land was settled in his favor in an OLR case 596 of 1980, applied for a certified copy of the order of settlement only on 20th January 1993. That is 13 years later. Full stop. Then again, he slept over the matter and issued a legal notice to the collector Puri 6 years later on 29 January 1999 not to lease out the land to anybody as he is holding the property. Full stop.
My lord, the
a writ petition was filed
only
in 2000 to direct the collector to reconstitute the case record of OLR case number 596 of 1980. Full stop. By this time, 20 years had already passed. Full stop. Some lease cases were already in progress. Those lease cases were dropped by the Tahsildar, Brahmagiri, in 2002, on 8th August 2002. Full stop. Paragraph. The attempt by the appellant for a direction to the opposite parties to reconstitute the case record in the aforementioned OLR case formed the subject matter of the writ. So that has been dismissed by the impugned order of the learned single judge, noting that submission on behalf of the state authorities that the case record was not traceable as it had been lost. Full stop. Consequently, no direction could be issued by the learned single judge for reconstitution of a record that has been lost. Full stop. Paragraph, having heard learned counsel for the appellant as well as learned counsel for the state, the court is unable to take a view different from that taken by the learned single judge. If indeed the entire record is lost, it will be a futile attempt on the part of the court to direct its reconstruction. Full stop. The appeal is accordingly dismissed and order 6 to us.
Supplementary list item number 3.
Permitted to
Counsel, the appellant seeks leave to withdraw the present appeal. Dismisses withdraw.
Item number 4.
Please, my lord. My lord, here the order passed by the honorable single judge is not challenged. My lord, honorable single judge, though in fact also allowed this revision, instead of my lord the imposing the sentence for 1 year, there was an order that imposing the sentence only for 7 days. So only, my lord, my prayer, because the petitioner himself was a lunatic, he himself cross-examined the witness, he himself done his case before the court because the lack of this legal knowledge, he has committed a mistake. Only, my lord, that this order, because already 15 years has already been elapsed. Considering that aspect, this honorable a sympathetic view. Only my prayer that let this 7 days maybe.
No. Let him at least go 7 days, sir. Having examined the impugned order of the single judge.
Para
Court
10.
notes that
30.
already a lenient view has been taken of the matter. And the conviction, the sentence has been reduced to RI for just 7 days. To stop, certainly the appellant cannot be agreed by the reduced sentence. To stop, this is irrespective of the fact that the appeal itself may not be maintainable against such an order in a criminal revision case. Paragraph, the appeal is accordingly dismissed. No order.
My lord, the order, writ appeal number 120 of 14, full bench decision, the writ appeal is maintainable. I have stated.
Anyway, it's all right.
Item number 5.
My lord, the order of the honorable single judge dated 1/11/16 passed in OGS number 11016 of 2000 is under challenge, my lord, where this court is the appellate court under the SI Act against the order of the passed by the SI court, my lord. And in the case, so far this case, fact of the case is concerned, we claim some interest. And the GRIDCO authorities disputed the interest. If once it is disputed, it comes under section 75G of the ESI Act, my lord. Therefore, entertaining a writ application is not just and proper in view of section 82(2). And other aspect, my lord, it is also a referral court on section 81. Therefore, the order may be set aside and liberty may be given to the affected party to approach the ESI court. This is my only submission, my point of law.
There's a settlement between the two of you, sir. That's how they've not disputed the demand at all.
My lord, the honorable single judge says you sit with the GRIDCO and settle the matter. It is a statutory right, my lord, to recover the interest. If it is not ready within time, 39 under section 39, 5A, may I place that provision, my lord?
Yes.
My lord, 39 5A says like this.
What is the harm? What the single judge is directing?
No, I'm not speaking anything harm to me. I'm speaking only about jurisdiction. Both the parties will lose a forum.
Yes.
Because this court is the appellate court.
Yes.
Not the original court.
Yes.
the object of the act will be frustrated by this.
It's all right. You see, the
This is
challenge
my
to present
submission.
appeal is to the order dated 1st November 2016, passed by the Learned Single Judge, disposing of OGC number 11016 by the respondent, Grid Corporation of Orissa Limited, bracket Gridco, assailing the demands made by the present appellant. For interest on the PF dues, ESI dues, full stop. Paragraph. The Learned Single Judge noted, on perusal of the pleadings, the Learned Single Judge came to the conclusion, on perusal of the pleadings, that there was obviously some form of settlement between the parties on the payment of ESI dues by Gridco.
That is a presumption by the court.
Yes. Full stop. It is observed in para 5 of the impugned orders under, take from page 75. The words now question remains undetermined, perhaps any material, up to arrived at, that whole paragraph, remaining part. Paragraph. Since the question of interest remained in doubt, the Learned Single Judge remitted the matter to the ESI Corporation to sit with Gridco and take a decision on the question of interest, referring to the records and providing a chance of hearing to Gridco. So, in other words, all that has been done is to merely ask ESI to re-examine the matter after giving chance to Gridco of a hearing. So, the court is unable to find any prejudice being caused to the appellant by virtue of the above direction. No grounds have been made out to interfere with the impugned order of the Learned Single Judge. The appeal is dismissed.
Supplementary list item number 6.
Item 6, my lord, I'm there on BC. My lord, may I pray for tomorrow, your lordship?
It's a 312 days delay, sir.
My lord, that delay part, if your lordship may kindly consider, I had a review application. After dismissal of the review application, I had filed this writ appeal, your lordship.
When was the review application dismissed?
Your lordship, that was dismissed on
18/11/2016.
Your lordship. I filed this appeal on 19/12/2016, your lordship.
All right, let's see the impugned order of the Learned Single Judge.
My lord, I was praying for tomorrow, your lordship. Can I?
No, sir. For us, it is inconvenient. Only today is inconvenient for us, sir.
My lord, just to assist your lordship.
No, sir. We are your assistance is extremely valuable. We understand that, sir. We request you to give us that assistance today, sir. All right. Continue, sir.
Can I seek a passover, your lordship?
Yes, yes.
Item number 7.
May I please, Lord?
Yes.
Here I have filed a short note, my lord.
Yes.
The only question arose whether the order passed under section 9(3) of the OCH and PFL Act can be annulled under section 15(1) of the OCH and PFL Act. Now, this point has been answered by the appellate of the Revisional Court, and the Learned Single Judge has not touched this point. The order passed under section 9(3) of the OCH and PFL Act in respect to suit land in favor of the petitioner under Annexure 3 series has been reversed by order of same CO under section 15(1), that is under Annexure 4. We filed appeal. Appellate court set aside the order passed under section 15(1) on the ground that the order passed under section 9(3) cannot be assailed under section 15(1). 15(1) says that only the cause of action subsequent to section 9 of the Act, my lord. Section 59(3) and section 15(1) of OCH and PFL Act. And the Revisional Court as well as the Learned Single Judge has not touched the point that whether the not answered the point that the order passed under section 9(3) is unchallenged till date. So section 15(1) cannot be appellate authority to reverse that order.
Kindly read the provisions, sir.
That section 9(3). And section 9 is publication record and issue of extract and notice. Under section 9(2), Parcha was issued, and under 9, CO passes the order. Any person to whom a notice, I am reading section 9(3). Any person to whom a notice under section 2 has been sent, or any other person interested may, within 30 days of the receipt of the notice and the publication of subsection 1, as the case may be, file before the assistant consultation officer objection on the correctness of entries in the records and extracts furnished therefrom, or in statement of principle or relating partition. And kindly then come to section. It is applicable under section 12. Come to section
9(3) is not an order. 9(3) simply says a person to whom notice issued can file objection.
Section 10 is order. Section 10 is order, my.
Correct.
Yes. Section 10 is disposal of objection under section 9.
Correct.
Yes.
So the order is passed under section 10.
10. Now kindly come to section 15. Decision matter relating changes and transaction affecting right of interest recorded in revised records. All matters relating to changes and transfers affecting any of the rights, title and interest in the land register published under section 13, for which cause of action arose after the publication of records under section 9 may be raised before the assistant consultation officer as and when they arise, but not later than the date of publication of the order, if any, under section 1 or section 5. Madam, the only cause of action after land records prepared under section 9, 15 objection case can be filed. But the order passed under section 10, the objection under section 9(3) decided on section 10 cannot be revised under section 15(1). Only the cause of action arose after publication of record under section 9. Those objections, any transaction after section 9 Parcha, that only we consider.
What is the timeline, sir? When was the section 10 order passed? When was the...
In my read petition, my lord, I have made annexure, kindly come to read petition, my lord. That is tagged with the file. 9(3) order, section 10 order was passed on 22/7/81. Order under section 10. And order passed under 15(1) was passed on 22/8/84.
More than 3 years later, sir.
The section 15 order was passed in favor of the OP number 2. Reversing order passed in favor of the petitioner in 81.
Does it actually reverse? What is the order passed under section 15? Where is that? Which page?
Section 15(1) order is annexure 4 at page 24 to 29 of the writ petition.
Annexure 4.
Annexure 4, my lord. Annexure 4, page 25.
Yes.
The present, before that I am reading. In the initial stage of section page 24. In initial stage of consultation operation, corresponding High Court so and so, recorded in the name of Gopinath Senapati Sabik Roy. The plot has been divided into 2 equal halves. Half has been recorded in the name of Bonshidhar.
No, he is not reversing any order, sir.
Madam?
He has not reversed the order.
He has recorded, ignoring the fact that the same land...
That's different. He's not...
same land has
some kind of a review petition. He's not done that.
No, madam. Same land has been settled under section 9(3). That has not been taken into consideration. My party.
Anyway, that you challenge and appeal, then it's
yes, appeal allowed in my favor, madam.
And revision went against you.
Madam, section, annexure 8.
Let's go to the merits, sir.
Annexure 8 appeal was allowed in my favor.
All right.
But then they filed revision.
Correct. And they
Now
succeeded.
revision was allowed.
Ah,
I filed writ petition.
correct. You
In
lost
the-
the writ petition. Correct.
In the meantime,
Yes.
the private opposition died having no issue.
All right.
The revisional court has passed order that the record will be recorded in the name of OP number 2.
Right.
Now OP number 2 is died issueless. I have filed affidavit. Only on basing on the records granted by state, we have been our order has been passed under
So
section
there is
9.
no stay granted by this court.
Yes, madam.
So what?
Madam, we have been directed to submit 2 extra copy. I have served. Madam.
No. Has any stay been granted here? No. Has any stay been
No,
granted
no,
by this
no
court,
stay.
sir?
No, ma'am.
Then whatever is continued.
Man,
is
annexed
continued.
3 series order is unchallenged.
Right.
So the party annexed 3 order, 3 series order under section 9(3) has not been touched by any other.
No, sir. The recording of the rights in favor of the respondent took place 3 years later
Ma'am,
in independent proceedings.
Now, under
by the
section
consolidation
51,
officer.
there is no cause of action to file objection case under section 51. My only grievance is that no cause of action arose after granting of parcha under section 9 to file objection case under section 51.
Yes.
As because investor self-sold and 9(3) order is there. Now contesting private.
Let's see the impugned order of the single judge, sir.
Sir, that point has not been touched, madam.
Which page is the single judge's order?
Madam, you start from assailing the same. Madam, page 1.
Sir, the order of the single judge.
Yes, madam. I am reading, madam.
As page, my lords may kindly go to page 13. That's where it starts.
It's 9/12/2016.
Please, my lords. It's page 14, third paragraph, my lords.
Assailing the same Sri Mahanti, Lawrence, may I read, madam? Madam, may I read the order?
Yes,
madam?
yes, character. Kindly read, sir.
Assailing same Sri Mahanti, Lawrence Council petitioner, contended that initiation of objection case, since was raised under section 15(1) of OCS and PFL Act, there has been illegal endorsement of the appellate authority which is not justified, and the revisional authority has failed to consider this aspect. Sri Mahanti, in assailing revisional order, also contended that opinion arrived in the operative part of the order remains contrary to the material available on record, and claimed that the order has been passed on improper appreciation of the materials available on record. Upon the above circumstances, Mahanti, Lawrence Council petitioner prayed for interfering in the revision and to set aside the same. Sri Das, Lawrence Additional Standing Counsel for the state, on the other hand, following impugned order passed by the revisional authority, referred to observation and finding of revisional authority in last paragraph of the revision order, submitted that the observation made therein, there is no infirmity in the revision order, leaving any scope for interfering in the same. Perusal of the pleadings, it appears that petitioner, though filed writ petition in the 1998, but brought new facts by way of amendment the writ petition in 2016, and it appears to certain new facts. Considering rival contention of the parties and facts and circumstances involved, this court finds the revisional authority allowed the revision on the premises that the documents relied upon by the present petitioner cannot be accepted for the reasons apparent on the face of it. Further, for the correction being undertaken without having attestation to entries to that effect, documents appear to be manufactured and further the revisional authority has also based his revision that the petitioner had the sole case on same oral submission which cannot be accepted. Mr. Mahanti, though made submission that the finding of revisional authority contrary to the materials available on record, but he is unable to satisfy the same by referring to any such document. In absence of any material contrary to the finding of revisional authority, the court finds no scope to interfere in the impugned order. Now, this is the order.
The present appeal is directed against an order dated 8/12/2016 passed by the single judge, dismissing 9/12/2016, dismissing the appellant's OJC number 6231 of 1998. Full stop. In the said writ petition, the petitioner had assailed an order passed by the revisional authority under section 36 of the Odisha Fragmentation of Holdings and Consolidation of Holdings and Prevention of Fragmentation Act of Land Fragmentation of Land Act 1972 bracket OCH and PFL Act bracket paragraph. Clearly, the appellant had filed objections under section 9 bracket 3 of the OCH and PFL Act, and an order in its favor had been passed. In their favor had been passed under section 10 of the said act by the consolidation officer. So 3 years later, in revision case number 6 of 1998, sorry, 3 years later, the order was an order was passed in favor of opposite party number 4. Is it respond number 4? Respond number 2.
At present, there is no private opposite party. Private restaurant, there is no private restaurant because restaurant died on married.
Yeah, who was subsequently died. Full stop. The contention of the appellant that an order passed under section 10 of the OCH and PNFL Act would not have been reversed under section 15 bracket 1 thereof does not appear to be correct. Full stop. On perusal of the said order, it appears that it was not passed by way of reversing the order passed 3 years earlier under section 10 PCH and OFL Act. Full stop. The learned single judge, as in the impugned judgment, observed is under. Take from the last para of the second internal page of the judgment of the learned single judge, considering the rival submissions up to impugned order. Paragraph. There have been concurrent findings of both the appellate authority, the revisional authority, and the learned single judge. No, by the revisional authority and the learned single judge. The court is not inclined to interfere. The appeal is accordingly dismissed.
Item number 8.
Item 8, your lordship, matter has become infructuous.
The appellant states that the appellate's appeal has been rendered infructuous. It is disposed of as such.
Item number 9.
9 melody infructuous.
Infructuous dismissed.
Item number 10.
May I please your lordships?
Yes, please.
My lord, today I have filed the second copy of option petition.
Tell us what the main matter is about.
My lord, the main matter of I challenge the judgment passed by the Honorable Single Judge of this Honorable Court under Annexure 6 before this Honorable Court. My sole contention was challenging that this appellant has some agricultural land and the loanee has taken loan mortgaging the land of this appellant, the agricultural land. And when he failed to make the payment of the loan, then the OSFC put the property into auction. In auction, this respondent number 1 who died respondent number 1 is void. So the under regulation 2 of the OSDLR as well as the appellate authority, both the courts passed order in favor of the appellant. being agreed by the respondent by those orders has filed the writ petition before the honorable single judge.
Against you, sir. Section 29, you cannot have independent. You'll have to have a separate procedure for that.
And the honorable, my lord, I could
What
not
is
have it.
decided is absolutely correct, sir.
Section 29 of the Orissa State Financial Act, without taking permission to transfer the property, is illegal. And this general act cannot override the special act, my lord, as the judgment passed by the honorable Supreme Court in many judgments. The special act is different from the general act. Relying upon the judgment passed by the honorable Supreme Court in the case of the Assam Land Reforms Act, saying that the permission is not required. But recently the Supreme Court held that in case of agricultural land, it is not come into force. So in view of those judgments, it is have a good case, my lord, to interfere into, because the land belongs to tribals. And under section 3(1) of the regulation 2 needs permission. And to side by side, the honorable Supreme Court said that the agricultural land can't put into auction. So section 29 of the Orissa State Financial Corporation cannot override the special statute regulation 2 of 1956.
All right, we pass the order. So we're not inclined here. The appeal is dismissed. We pass the detailed order. Right.
Supplementary list item 11.
None appeals dismissed.
Item number 12.
My lord, on the question map of this item to pass over.
Pass over. All right.
Item number 13.
Item 13, your lordship, I'm appearing through VC, your lordship. Your lordship, on behalf of Mr. N.K. Mohanty, I seek for an adjournment, your lordship. Mr. Mohanty presently is in the hospital for his wrist is broken. So he has gone to the hospital.
Sorry?
His wrist is broken.
I see.
Lordship.
Mr. Mohanty is stated to be unwell. List. List on 12th January.
Supplementary list item 14.
May I please, your lordship? I am for the respondent, your lordship.
None appeals to the appellant dismissed.
Supplementary item 15.
15, I am for the respondent.
None appeals dismissed.
Item number 16.
None appeals dismissed.
Item number 17.
For the respondent 2 and 3. Respondent 2 and 3.
My lord, item 17, infectious.
Infectious dismissed.
Item number 18.
Item 18, my lord. The delay is there, my lord.
What's the delay, sir?
My lord, delay is, as per my calculation, around 300 days delay, my lord.
The delay of 300 days unexplained. MC number 69 of 2017 is dismissed. Accordingly, appeal is dismissed.
Item number 19.
May I please, your lordship? Your lordship, I am for the appellant. May kindly see the noting, your lordship.
What's the delay, sir?
Delay of 51 days, 59 days, your lordship.
But you've not taken any steps for over 5 years now.
Indeed, your lordship.
For 5 years, no steps for limitation have been taken. Appeal is accordingly dismissed, not possible. All right.
Item number 20.
May I please, your lordship? I am for the appellant, my lord. I am appearing through VC, my lord. The appellant has challenged the order passed by the honorable single judge, which was filed against the award dated 28/5/2016.
How is a writ appeal maintainable? Writ appeal is not maintainable for these things. In fact, writ petition itself is not maintainable.
My lord, after the MSA,
Writ petition itself is not maintainable, madam.
My lord, without serving notice to us, the award has been passed, my lord. In MSCFC,
There is a separate procedure for challenging that.
The liberty may be granted, my lord.
No.
My lord, already the payments has been made. The principal amount has been made as per the settlement, but the notice has not been served on the date of sitting of the MSCFC council, my lord.
The challenge, the present appeal is to an order dated 16 January 2017 passed by the learned single judge, dismissing the appellant's writ petition number, civil number 20420 of 2016. In the said writ petition, the appellant had challenged an order dated 28 June 2016 passed by the Director of Industries cum Chairman of the Micro and Small Enterprises Facilitation Council, Orissa, Cuttack, in MSFC case number 14 of 2014, directing the appellant to pay principal amount of rupees, principal and interest amount up to 31st March 2014 as per sections 15 and 16 of the MSMED Act 2006. The learned single judge noted that despite opportunity to the appellant by forwarding an application of claim to it to file a reply, no counter affidavit had been filed.
But my lord, there was an amicable settlement, my lord, where the
Yes.
principal amount has been paid, my lord.
Yes. Despite opportunities with no counter affidavit being filed, the appellant was not in a position to demonstrate that there was any settlement arrived at between the parties. Paragraph. The learned single judge was in the above circumstances justified in not interfering with the demand raised by the opposite party number. Having heard and counsel for the appellant, the court is unable to come to a different conclusion. There is no merit in this appeal and it's dismissed as such.
Supplementary item 21.
There is a delay of 101 days and the amount involved is only 25,000.
There's no convincing explanation for the delay.
In the impugned order, the
is
Honorable Single Judge
insignificant.
has directed to pay 25,000 to the
I see. The appeal is accordingly dismissed.
Supplementary item 22.
Delay. All right. None appeals dismissed. All right.
Item number 23.
None appeals.
Item number 24.
Not press, your lordship.
I'm not pressed.
Item number 25.
None appeals dismissed.
Item number 26.
None appeals dismissed.
I am for respondent 4, my lord.
All right.
Item number 27.
None appeals dismissed.
Item number 28.
28, may please, your lordship. Lord, I filed this appeal challenging the order of this honorable single judge passed in WPC number 2267 of 2017, my lord. Here, my lord, the present appellant has been in possession over this disputed parcel of land for over 30 years now. My lord, in 2007, he had filed a civil suit to establish his right title interest over the land. Thereafter, my lord, in 2009, an interim application had been filed to praying for interim injunction
So this
against
impugned order of the single judge was passed on 6th March 2017.
Yes, your lordship.
You were asked to vacate the premises within a month.
Yes.
What have you done? There is no stay in this by the division bench.
No stay.
What have you done? By the impugned order, the learned single judge required the appellant to vacate the land in question within a period of 1 month and also file an affidavit before the competent authority to the same effect. However, counsel, the appellant is unable to inform the court whether the above directions have in fact been complied with. It must be noted that this court has not granted any stay in the matter. Paragraph in the above circumstance, reason why it should interfere with the order of the learned single judge. The writ of appeal is dismissed.
Supplementary item 29.
May I please, your lordship. In this matter, my lord, there is change over of a management, my lord. The opposite party has been taken over by Tata Power Central Odisha Distributor Limited.
Tell us what the challenge is.
Here the order on the challenge Miller
17/8/2016 of the single judge.
Annex 12 Miller.
What is wrong with the order? Tell us.
The ordering portion page 70 Miller. May I read Miller?
Yes, please.
The inquiry officer came to a finding that the unauthorized extension work has been completed by the villagers to provide power supply to the house of Dushasan Bhoya village Anant Brahmapur by effecting 3 numbers of joists from canal chuck to the said village, and the said fact was within the knowledge of the concerned JE, SDO and manager electrical Jagatsinghpur. The aforesaid officers could not submit any written statement of defense regarding the unauthorized work and removal of first span during verification by CBO on 11 ticks. He further held that the illegal and unauthorized LT extension work was executed by the villagers, but all the officers from the section to division knew the facts. The appellate authority set aside the order of punishment and reinstated the petition in service. The 3 annual increments with cumulative effect of the petition have been withheld by the appellate authority. The appellate authority held that the period of dismissal shall be treated as a breach in service and no remuneration for the said period shall be paid. From the inquiry report, it is crystal clear that the factum of supply of LT was the knowledge of other officers and the LT connection extension was executed by the villagers. No reason has been assigned as to why disciplinary proceeding was not initiated against the said officers. Furthermore, neither the copy of the inquiry report was furnished to the petitioner nor any second so-called notice was issued to him. On this score, the order of punishment is liable to settle cost and the matter ought to have been remitted back to the disciplinary authority. But the appellate authority took a lenient view in the matter to set aside the order of dismissal and reinstate the petition in service. In view of the same, instead of remitting the matter back to the disciplinary authority, the matter is remitted back to the appellate authority. The appellate authority shall do well to consider the quantum punishment imposed on the petitioner within a period of 3 months. Here, Miller, though other officers are involved, another has been exonerated from the charges, Miller. That is at Annex 13, Miller. Arrangement same incident, Miller.
It's all right. Facts will be different vis-a-vis each of them.
No, same setup in there. You do another
involvement of each of them will be different, sir. The fact that the others got exonerated doesn't mean automatically you get exonerated.
The name of that delinquent also find place in the charge memo of the petitioner, Miller.
All right. What else?
Annex 14, Miller.
Yes. It's only a remand order, sir, to the appellate authority.
Miller?
On quantum of punishment, it's been remanded to the appellate authority. What is wrong with that order? No state. By now, it will all be infractuous.
Let me to obtain instruction what is done by the appellate authority.
You're not actually. You say all that has happened by the impugned order of the learned single judge.
Miller.
All right. Counsel for the appellant seeks leave to withdraw the present appeal. Dismiss this matter.
Liberty may be granted, Miller.
For what?
Because in the meantime, what the appellate authority done, that is not within my knowledge, Miller.
It's all right. We don't interfere. That's all, sir. You say all that has happened by the impugned order of the learned single judge is that on the quantum of punishment, the matter has been remanded to the appellate authority. Paragraph. The court sees no reason why it should with the said remand order. There's no merit in the present appeal. It's dismissed. All right.
It's simply written, Miller.
Don't go on swinging like a pendulum now. That's over now. Yes.
Item 30.
30, Miller, not pressed. This matter
not pressed. Dismissed. It's not pressed.
Item number 31.
May I please, Your Lordship?
What's the delay, madam?
Delay of some days, well.
Let's find out.
And now when the matter was disposed of, respondent number 3 had already died in 2006, and the order was passed on 2017. And now the legal heirs of that defendant opposite party number 3, they are before Your Lordship, my lord, and I have immediately thereafter one application was filed for recalling that order also. That is, I see that yesterday only at 10 o'clock I saw the list, and I found out that that is also pending in the writ application. Writ application, the counter affidavit, very big counter was filed, but that was, the order was passed when the advocate for the opposite party number 1 and 4, myself, my lord, I missed the list so that I could not be present on that date. And the order was passed immediately thereafter. Recalling order was filed and that is pending. Now the writ appeal
When
also.
is it coming up? You have not mentioned it for listing.
Now.
When is the recall application coming up?
That is 91 till today from 2000. Only first time it was listed in 2017, most probably writ application. Then thereafter 91 by 2017. That miss case. That has not been listed.
Coming up, sir?
That is pending.
No. Pending means you're not mentioned it for listing. Have you mentioned it for listing?
Several times at that time, I would have tried. Now, after
Would
5
have
years,
tried.
I
You don't
cannot
know whether
say
you
that.
actually tried or not.
It is. And that writ application 2000 and it was
Is it
listed
pending?
in
Is
the
that
year
writ petition has been dismissed?
that was on without any without looking to the counter affidavit file, and there was no error on the apparent of the case record. The consolidation commissioner has rightly passed the order, and only on the ground that there is delay.
Yes,
and
revision
actually,
petition
in
is-
fact,
12 years later, you're filing revision petition. No wonder.
no, my lord. That section 15A, your lordship may see survey settlement. If there is an error by the officer committed, then the commissioner has every right to correct it. And accordingly, that was corrected. And the writ petition was filed without disclosing the correct facts, because that property was purchased by the number 1 and 4. And that was the report was there before the consultation officer. All the records were there and the notices were sent to the party. These writ petitioners, they did not appear in the case, and accordingly that order was passed. Your lordship may see from 2000 I have prepared the short note. Your lordship may see my bona fideness. That from the papers, your lordship can know that short note I have prepared, and I have given all the facts. And looking into if the counter has been filed, the Lord and single judge has not looked into that and passed an order. And as the Act provides that also, that yes, if any error has been committed by the office, then that can be corrected. And accordingly, that has been corrected by sending due notice. I have given here, lordship may look to my short note.
There's a delay of 17 days.
Only.
The delay of 17
From the
days.
papers, your lordship can know that I am ready from 2000, but 2017, it was dismissed.
No, you're not taking steps for even filing an application for continuation of delay.
That only writ appeal I have mentioned that from the date of the knowledge, I came to know from the
You
other
have to
side.
file an application for
Then
delay.
your lordship may grant some 10 days time so that I can do everything. Because only that thing, otherwise it will be injustice to the party because by virtue of a sale deed. And what happened, my lord, that is...
The counsel for the appellant seeks some time to file an application for continuation of delay.
And the
List after
substitution petition if necessary.
List after the application and seeks a week's time for that purpose. All right.
Item 32.
May I please, your lordship? I am submitting on behalf of Mr. S.S. Samantha, lordship. Lordship, the appellant challenges the impugned order passed by the honorable single judge in WPC number 4076 of 2017, your lordship. Lordship, the fact of the case is that the petitioner was allotted to the plot by annexure 1, your lordship. Page 18, your lordship. And thereafter, he has also filed a letter application to grant another adjacent, just adjacent to the plot of the petitioner, your lordship, applicant, your lordship. Thereafter, filed several representations before the OP number 3 to grant the same, and also deposited a twice amount, which is the total cost of the land. And thereafter, in the GB meeting, they have also considered the same. By annexure.
There's already a direction issued in the earlier petition, sir, by the division bench.
Yes, your lordship.
All that the single judge has said is follow that direction. That's all.
Yes, your lordship. But till now, they have not allotted the land, nor made.
You have to participate in an auction.
So till that, no auction has been made, no letter has been communicated, nothing has been done by the opposite party.
So you have to file a contempt for that, sir. Not again, writ petition, you can't keep filing.
Lordship,
You
I'm
should have
just,
filed a contempt. If they are not complying with the order of the division bench, you should
Yes,
file a
Lordship.
contempt.
Yeah, Lordship,
Any of
my-
those directions have been again asked to be complied with.
Your Lordship, my humble submission that
Yeah.
the order passed by the single judges, they have not complied the same also. Your
So you should
Till
file a
date.
contempt, sir. You can't file a writ appeal. The order is in your favor.
Yes, so let's
The
till date.
impugn order dated 29th March 2017 of the learned single judge merely reiterates the earlier directions issued by the division bench in favor of the petitioner on 9th February 2006 in writ petition civil 14842 of 2005. Full stop. If according to the learned counsel for the appellant, the impugned order of the learned single judge has not yet been complied with, then the remedies to there are other appropriate remedies to seek. Full stop. The filing of a writ appeal is not one of them. Full stop. Consequently, the court finds no constitutional writ
Lordship,
appeals.
my annex 11 annex representation filed before the opposite party is pending. Let them consider.
That's okay, sir. Right.
Supplementary item 33.
To 5, my lord, in this case.
All right.
BDA for BDA. my lord.
Item 33.
None appeals dismissed.
Item number 34.
May I please, my lords? Well, here I have assailed the decision of the Honorable Single Judge. Lordship may look at your Lordship's kind look at page 86. The petitioners are being aggrieved by the order. Your Lordship may permit me on 2 grounds I am challenging this order. Number one, my lord, the Honorable Single Judge constitutes section 32 of the Odisha Survey Settlement Act as a forum, treating it as an alternative remedy.
Who's appearing with the other side?
My lord, notice, no notice. Sir, state is all opposite parties. What happened, my lord? In the writ application, an order passed
No,
under
notice has
section-
not gone to the opposite party.
My lord, your lordship may look at my cause title. All state authorities, my lord.
Just see the order dated 16th August 2017.
My lord, sorry to say that the file is not with.
I see.
Can I
Please give him a copy of the
Order.
paper book.
Or
Just, yeah.
yes. Yes. It is there. This is of the year 2017.
All right, Mr. D.K. Manthi seeks some more time to examine the matter in light of the order dated 16th August 2017 and file an affidavit. Second February.
May I request my learned friend to
A complete set of the paper books be supplied.
My sir, by tomorrow I shall serve.
All right.
Item 35.
On behalf of Chairman Mahaputra, file is misplaced. Kindly taken up next week.
No, it's all right. It is stated that the file has been misplaced. The appeal is accordingly dismissed, not prosecution. With liberty to the appellant to revive the file is able to be traced.
Item number 36.
May it please, Milords. Milords, I am appearing through virtual mode. Milords, I appear on behalf of Mr. Acharya. Your Lordship, his mother is unwell. She's admitted in the hospital. So I seek an adjournment on the same. So kindly the matter may be taken up maybe after 10 days.
Also, the appellant is stated in some difficulty today. This on 15th February.
Sorry.
Item 15th February. Item 37.
Delay. All right. None appeals dismissed. All right.
Item 38.
None appeals dismissed. Yeah, up to 39 also.
Item 39.
39 same.
Item 40.
Please, your lordship. The order under annexure 1 passed by the Honorable Single Judge 9-5 it is under challenge. The lordship may kindly glance. Page 2. Or by the Honorable Single Judge without appreciating the fact and contention. As was the annexure 10 with the registration certificate is issued in favor of the institution by which the original petitioner was neither aggrieved nor any cause of action was sustained in his favor. Lordship may page 32, para 20. In view of the aforesaid fact and circumstances, this court is
There is no stay of this order. By now it should have worked itself out, sir.
My lord?
There is no stay of this order.
No, the entry matter is there.
Where?
Entry matter was there.
I see.
Under 23/6/2017.
Yeah.
Para 20. The in view of the fact and circumstances, this court is of the considered view that the registration certificate issued on 31/1/13 and 10 on the basis of report dated 31/7/12 cannot be sustained in the eye of law, deserve to be quashed. Accordingly, the certificate registration issued on 31/1/13 and 10 hereby quashed. The opposite party number 4, Collector Kendrapada, direct to issue a fresh certificate registering this registration, taking into consideration report of district education officer Kendrapada dated such and such, report of the video dated such and further repeated very same officer dated is annexure B/5. The entire cell completed within such and such period. A lordship may kindly have glanced to the annexure 10 to the writ petition. First, for lordship's convenience, annexure 2, the writ petition.
What item?
At page 22, the certificate of registration of societies. Lordship may got it.
Come to para 12 of the judgment.
Well, no doubt the petitioner decided on the basis of statement on affidavit. If the petition contains misleading, incorrect statement, there is a suppression material fact, court will not entertain. But no suppression at all on the face of record. Lordship, annexure 10 mechanical glance. What cause of action accrued in favor of the petitioner, how he is aggrieved. Then this is the certificate of registration issued in the name of institution, Girls High School of Art, Aitipur Post Baro, Kendra District, Kendrapada. Then Lordship may kindly glance to what prayer he has made in the writ petition. In a clear cut of misconception, it is therefore prayed that may submit my lord. It therefore prayed that this honorable court make itself pleased to admit the writ petition, call upon the opposite party to show cause upon their showing cause, failure to show cause to allow writ petition, issuing appropriate in nature of mandamus, to quash the certificate issued in favor of the opposite party number 6. My submission that opposite party no certificate was issued in the favor of opposite person, rather in the opposite by in the institution for which the original writ petitioner or the respondent here was claiming to be the secretary. So in the institution or the certificate issued in favor of institution in a wrong premises, he has filed the writ petition in misconception and order has been passed. Your lordship may furthermore, the lordship may page 5, para 6. The himself admit the petitioner on that on 23/9/11, the petitioner applied for registration of the managing committee. The writ petitioner was himself applied for registration certificate, and he is alleging that present appellant was applying for registration. But the question is that applying a registration of the certificate in favor of the institution. But 23/9/11 document was never filed. When there is a dispute in para 1, what is the contention? The very dispute in guise of approving himself as a secretary, the writ petition was held. Para 1, my lord. That the present writ application, not only in the action of the opposite party number 3, is not transmitting the documents, important, my lord, submitted by the petitioner, for our approval of managing committee, but the collective steps taken by OP 3 to 6, inaction leading likely to be approval of fictitious managing committee. So the dispute between the petitioner and the appellant here, they are claiming to be the secretary, the managing committee. But so far the annexure 10 is annexed to the writ petition which has been quashed by the honorable single judge. That is nowhere related to the dispute between them. Why the institution will suffer between the fighting between the two persons claiming to be the secretary. For that purpose, Lordship may kindly have the counter filed by the OP 124, the government. That will suffice the what is the issue involved. Para internal 3 of the counter, para 7.
Counter in the writ petition.
Writ petition. That has not taken into consideration. Para 7.
That the lands were purchased.
That it is humbly submitted.
1 minute. Counter is of respondent number
1 to 4. May I submit my lord?
1 minute. Yes. Para 7.
That it is humbly stated that the society has been formed to meet the educational need of this locality with specific focus on needs of girl students. If the society registered, I am just emphasizing, if the society get registered, it will not affect the interest of the petitioner in any manner. His sole intention to be recognized as the secretary of the institution in place of opposite party number 6. Here is the appellant, Bhavya Das. This claim can be adjudicated through other means, but not by cancelling the registration. Your Lordship, para 9. That it is respectfully submitted, the prayer of the petitioner to cancel the registration of school under Society Registration Act is thus misconceived as not in the interest of the institution. So that aspect has not been ever considered by the honorable single judge. That with a misconception that certificate issued in the name of the appellant.
Appearing for the other side?
The state as well as the...
No, there's somebody for the school, right?
For the respondent number 1. So far as the question of suppression, which my lords rightly pointed out, that is there in the impugned order, paragraph number 11, that is there.
No, suppression by you or by him?
Not suppression by him in the previous writ petition, that is there. That has been analyzed also.
This writ petition was your writ petition.
My lord, that is there. And that was taken note of how there was suppression in the previous writ petition. An order was obtained to consider the case for registration. But that has been taken note of, and on that basis, my lord, judgments have been relied on to indicate that is at paragraph number 11, my lord, of the impugned order.
Yes.
May I place it, my lord?
Yes.
In view of the candid admission to the extended made by BDO in paragraph number 7 of his counter affidavit, there is no justifiable reason to grant certificate of registration in favor of opposite party number 6 managing committee. In addition to that, opposite party number 6 has not approached this court with clean hands, meaning thereby opposite party number 6 had approached this court by suppressing the material fact that he had earlier filed an application for grant of certificate of registration on the basis of the reports of the BDO dated 8/11/2011 and DEO dated 28/9/2012. Rather, he has relied upon the letter dated 31/7/2012 of BDO and sought for a direction with an innocuous prayer that Dr. Kendrapata should take a decision on the basis of the letter dated 31/7/2012 with regard to grant of certificate of registration in its favor. But here, my lord, the issue was that, my lord, two managing committees, initially, lordship may kindly come to my rejoinder affidavit, where I've annexed the resolution whereby the committee was formed. That is, my lord, on 11/6/1989, the managing committee was formed. Thereafter, my lord, this appellant, who was the opposite party number 6 before the honorable single judge, he resigned, my lord, from the post of secretary. Resignation letter is also on record. Thereafter, my lord, this respondent number 1, who was the petitioner before the honorable single judge, was the secretary, and the committee continued. And this person, in fact, admits that he was not the secretary. That part has also been taken note of, if lordship kindly comes to paragraph number 17. Paragraph number 17 of the impugned order. That has also been taken note of, that in all the subsequent events, this person was not there. In fact, this person himself admits that he was never the secretary. After resignation, he was not the secretary. The resignation order is also there.
All right. Yes, please.
Then para 11.
Yes.
In view of the candidate admission extent indicated of the video para 7 is counterfeit. There no justifiable is no grant certificate registration in favor of the opposite party number 6. So Annex 10 is the certificate issued in favor of the institution. That is the error apparent on the face of record. No certificate issued in favor of the appellant who was the opposite party of seeking the writ petition. So that is the misconception created by the petitioner and obtain an order. Suppression of fact. Your lordship may kindly glance that order, that innocus order that has quoted in the writ petition at page 6. What was the order? 12/12/2014, my lord. May I place my lord? On 12/12/12, this honorable court by writ petition such and such was to pass the following order. Had Mr. Such and such, the present writ petition has been filed by the petitioner seeking direction to the collector Kendrapada to take a decision on the basis of representation made by the BDO Kendrapada by the order 31/7/12 under Annex 1, seeking the nature of prayer and the interest of the institution as well as the students of the writ application disposed of with a direction to the collector Kendrapada to take a decision on the recommendation made by the BDO Kendrapada under Annex 1 within a period of 3 weeks, receipt of certified copy of this order along with the writ petition. When a counsel petition undertakes to submit that order along with the copy of the application. So that innocus order, even if he agreed by that order, he has not challenged that order by way of challenging writ appeal or anything forum. Furthermore, the initial order is not challenged. The subsequent order of certificate he is estoppel to challenge that. Foundation is not challenging. Moreover, the Honorable Single Judge has held that in para 11, the certificate issued in favor of the opposite party number 6. Apparently, face of record, Annex 10 is issued in favor of the institution. So the institution should, my humble submission, institution suffer due to the fighting between the present appellant, even if the claiming took the secretary and also the opposite party number respondent 1 with the writ petitioner.
You're not inclined, sir. We pass the detailed order. The writ appeal is dismissed.
Item 41.
Please, my lord. Some appeal, my lord, challenging the judgment of the honorable single judge. It is in fact an order, my lord. But here, my lord, few issues are involved in this case. Lordship permits, my lord. There is a short delay, as it has been pointed out. There is a miscase for delay. Delay of around 20 days, perhaps.
All right, delay is condoned. Can you go?
Here, the issue is, my lord, by the impugned order.
Impugned order is 12/4/17. Writ petition has been filed on 8/6/17. Therefore, there is a delay.
Delay is condoned, sir. Let's get to the merits.
I am for the respondent number 1.
Delay is condoned. Carry on.
Mind. General, by the impugned order, Lordship sees the respondent number 1 against whom a proceeding was initiated for violation, my lord. Building was constructed by violating the guideline, violating the plan, my lord. There was encroachment. Proceeding was initiated. Order was passed. That was confirmed in appeal. Then it came up before this honorable court pursuant to an application for compounding the violation, my lord. There, my lord, while considering that application, the honorable single judge went on to set aside the orders passed by the forums, my lord, holding that he has violated and is liable to be, it is liable to be demolished. And there, while setting aside that, my lord, direction has been issued to consider for compounding.
Yes.
But my first submission would be,
yes,
Lord, by the process of compounding, my lord, the wrong which has been committed, that cannot be missed. That is one aspect. Committed? But once, yes, my lord, that is my point. But before I'll take my lord to the writ petition itself to indicate, my lord, how, my lord, that order is not sustainable. Lordship may kindly come to the writ petition. I will take my lord. I will take my lordship for a moment comes there's a scheme, my lord, for compounding. And my
Yes.
lords know that the scheme is for a particular period, and the scheme provides that by a particular date or before a particular date, the construction has to be made. But there, in the scheme itself, it provides for a particular date, and there's a finding by the authority that the construction took place after that, and in fact, the construction continued after that. And the construction took place in the area which happens to be a road. But that is the point. Lord, kindly come to the repetition, my lord. For a moment, my lords may kindly come to Annexure 1.
Yes.
At page 16. Straight away take my lords to the relevant part, my lord. Relevant page is page number 19. On perusal of the records, along with the approved building plan, it is observed that the opposite party has taken approval of building plan by so-and-so, issued by letter number so-and-so dated 13/11/86, where there exists 12-feet approach road to the plot. On 29/9/2010, the planning member CD has reported that the construction of the work is continuing in the site. Earlier, on 30/11/2009, there was a single storage building. At present, there exists two building and third floor partly completed. As per the report of the planning branch, ICC Madhupatna, was also intimated by memo number so and so.
What is your interest? Why are you opposing this?
Lord, I am a resident of that area. Lord, I am using this road.
Road?
Yes, my lord. Everybody is using this. This is a road. Lord, that report has been provided. And also
that fact I am disputing. I am disputing that fact. It's not a road.
Let's hear him and then we'll hear.
But pursuant to the report of the Amin itself, this proceeding was initiated. Lordship sees this is one aspect. Lordship may see the next page, my lord, page number 20, my lord. The page number 20, the last paragraph where the findings has been rendered. But in view of the above, since the construction has been made after 2/1/2009, which was the cutoff date as per the notification, cutoff date of VR scheme, and such construction is made deviating to the approved plan, the same is treated as unauthorized and therefore is liable to be removed by demolition. The appeal was preferred. In the appellate forum, the order is, my lord, Annexure 3, my lord. Relevant page, lordship may straightway come to page number 25. Lord, the second paragraph, the last sentence, I will only rely on the last sentence, my lord. He further submitted that the construction undertaken at site cannot be regularized on compounding under the provisions of the Cuttack Development Authority Planning and Building Standard Regulation 2010, since in respect of left side setback and right side setback are beyond 20%. Accordingly, demolition order has been passed. This
Sir, just come to the impugned order. We'll ask him. Come to the impugned order. Kindly come to the impugned order, sir.
Yes, my lord. The Honorable Single Judge has directed the...
No. Let's see that order. Which page is the single judge's order?
Pardon? Appellate order.
It's no. 12th April 2017, single judge's order.
Appellate order, my lord.
It's a single judge's order.
Yes, single judge's order. My lord, first of all, the appellant has no locus standi.
Sir, first come to the single judge's order.
My lord.
Do you have it? 12th April 2017.
Yes, my lord. I have it.
Show us what is the reason for setting aside all the orders?
The reason is the Honorable Single Judge found that the application for clemency is within the period prescribed therein in this scheme.
How can you set aside the orders? If you have to be considering your case for clemency, how can you set aside the orders?
Well, this unauthorized.
Unless these orders are confirmed, the question of clemency doesn't arise. Can somebody file a mercy petition before a governor if he's acquitted? Will he file a mercy petition if he's acquitted? Only if his conviction is confirmed will he file a mercy petition, correct? Where's the question of clemency petition being entertained if the orders found against you are set aside?
No, the whole point was whether the clemency petition was within the prescribed time.
No, it is not only for that. Directed to consider clemency and take a decision from the date of production.
Yes.
By setting aside, the orders under annexes 1 and 3 are quashed.
Yes, 1 and 2, both orders. One order is passed by the
Sir, those orders are against you. It can't be quashed. What is the meaning of clemency, sir? How can there be clemency? If the order itself is quashed, where's the question of clemency?
Clemency scheme, for the first time, it was introduced for Kotak Development Authority and the Bhubaneswar Development Authority.
Orders clearly say these cannot be compounded. These are beyond compounding.
No, it was
the deviations made by you are beyond compounding.
Fact, let me make it clear. The clemency scheme has been introduced for the first time in Kotak Development Authority.
Correct.
Under that scheme,
yes,
it was again amended. First, the scheme came, and second, it was amended.
So these orders cannot be set aside. You're missing the point, sir. Clemency will come only if confirmed that you have made deviations which are not compoundable.
That is what the Honorable Single Judge has directed the authority to consider my application.
Who's for the CDA? You're not CDA. Who's for the CDA? What is your stand?
I don't have the appeal memo.
You don't have it all. So you know stand. Very convenient. This appeal has never come up earlier.
I'll give it.
Again, the appeal memo to the late matter.
I'll give a copy.
Delay condemnation.
All right. You say copy of the appeal memo be provided. Counsel appearing for the Kotak Development Authority to enable him to take instructions. This on 7th February. All right. Interim order to continue.
Item 42.
Sometimes you should find out. You people sit quietly. We keep hearing a matter for half an hour. You sit quietly down and without even telling us, I don't have a copy of paper book, nothing.
Matter is for delay condemnation.
Have you been hearing delay condonation for the last half an hour, sir? The minute matter was called out, we condone delay. And you're sitting quietly. Anyway. All right.
Item 42.
Item 42, my lord, I pray for a Passover.
2 weeks, man.
42 in this case, yes,
Mike, sir, Mike, can you use?
He has sought the delay condonation, but he has not given the appeal memo.
No. Who's for the appellant?
I am for the appellant.
Now tell us what is there in this appeal. What is the delay?
If your lordships may pass over the matter, Mr. Somyam says to do this matter. Lord.
51.
All right, pass over.
I do pleasure.
Item 43. That similar matter yesterday.
That His Lordship has kept it to 5th of December.
List on
some list I'll also supply the list.
All these three, 43, 44.
45 and 46 also, madam.
All right, up to
47 as well, madam.
47 also.
Okay.
All up to 47, just put one consolidated thing and list on.
Along with it, my lord, I have also given a list of 3 matters which have not been listed neither yesterday nor today. Sorry, my lord, I can only get one copy, my lord. I apologize.
So far as 45 and 46 are concerned, a delay of 50 days.
It's all right. We'll consider all that.
I kept all matters on the
45, 46 delay condone.
My lord has kept all matters on the 5th of December.
5th December. All right. List on 5th December. All right.
Grateful, man.
All right.
Item 48.
Pass over. Pass over.
Item number 49.
Limitations. None appears dismissed. All right.
Item 50.
50 pass over. All right.
Item 51.
None appears dismissed.
At 52.
None appears dismissed.
Item number 53.
None appears dismissed.
Item number 54.
54 sub item. 54 sub item infectious, let's see.
All right. Which sub item?
Sub item.
We are in 54, madam.
54 sub item WC 24393 of 2022.
24393. You're saying
24393.
no instruction.
No. Infectious, let's see.
Infructuous dismissed. The remaining none appears dismissed.
Item number 55.
It has become infructuous dismissed.
Item number 56.
My lord, I may be pardoned that item number 51, lordship called it that brief has been transferred, my lord.
All right, 51 you say for the
51 and
says
52.
brief has been transferred, none appears dismissed.
53, my lord, he is suffering from fever. Telephonic information given 53.
50?
Next week it may be
53.
Viral fever, he is suffering.
All right, in 53 you say counsel for the limitation steps not taken. Just see 53. What's the delay?
Telephonic information that
1 minute, 1 minute.
From,
All right, 1 minute. We'll see what the limitations. One day. All right. Counsel for the appellant is stated to be unwell. Yes, sir.
Item number 56.
56, I am for the opposite party.
None appears for the petitioner. It's all right. None appears dismissed. All right.
Item number 57.
Item number 57, my lord. I am in sub-item WPC 20582 of 2020, my lord. The senior conducting counsel expired in the meantime, my lord.
What's the matters about, sir? What are these matters?
I have just received the brief, my lord. I have instruction to appear in this case, my lord.
All right. We'll just see.
My lord, sub-item number 2186. That is regarding transfer of administrative tribunal cases from Berhampur to this.
They're all infructuous, sir.
Yes. Yes, my lord.
The entire lot is infructuous.
This is infructuous and 2186.
Yeah, all of it, sir. All of it is OA matters.
Yes, ma'am.
All infructuous is disposed of as such.
Item 58.
Transfer of case from the tribunal to this High Court.
58 also. Same. Infructuous dismissed.
Yes.
Item number 59.
None appears dismissed.
Item number 60.
My lord, item number 60, no instruction.
No instructions dismissed.
Item number 61.
None appears dismissed.
Item number 62.
None appears dismissed.
63.
None appears dismissed.
Item 64.
Item 64, 3 days time will be allowed for removal of
No, not for 9 months. You've not removed, sir. No
yes,
further.
But last chance, my lord.
No,
only
no,
3
sir.
days.
Sorry, sir. For over 6 months now, defects have not been removed. The court does not propose to grant any further indulgence. Dismissed. Sorry, sir. Yes.
Let's be at this matter, my lord. There.
Defect is not removed, sir. Why should we hear it? You've not removed the defect. For 6 months, you've not removed defect.
Only 2 days, my lord. Only 2 days, man, allowed, my lord, my lord. There is public interest litigation, my lord. There public are suffer, man.
For 6 months, you sleep over it. And now you're telling us the public will suffer.
Then only 35
you have not taken the single step to remove defect for 6 months. For 6 months, you've not removed defect.
My lord, sorry, my lord, let's say only 2 days, my lord.
This agitation that you're having now.
My lord,
so agitated.
Justice, my lord, only 2 days.
You're getting so agitated You could not bring up this agitation.
Sorry, my lord.
That's what pointed out.
I am very, very sorry, my lord. My lord.
Your clients will be very sorry, sir, to know that for 6 months you slept over a matter when it was so urgent.
This is so urgent. The public care supply, they increase the
So
electricity.
imagine
That, my lord,
what must be feeling when they know that for 6 months you slept over a matter.
Only 2 days, my lord, the decision power, my lord, the praise for only 2 days, my lord, the removal of the defect, my lord.
What is the matter about? That is. Tariff hike, there's other remedy, no? For tariff hikes.
Yes, there's an appeal under section 111 as well as review.
The challenge in the present petition is to a tariff notification of 27th March 2021 against the said, for the said grievance, there is already a remedy available under
section 111 of the Electricity Act.
111 of the Electricity Act, leaving the petitioners to pursue such remedy. The petition is disposed of. All right.
Supplementary list item 65.
Defects not removed.
Please, my lord. My lord, here, my lord, a person is languishing in jail custody since 2008, despite the direction and the best endeavor by this honorable court also. Division.
Why PIL, sir? Why PIL for these?
My lord, despite the direction,
the person to pursue it, sir. You don't. This is not a PIL. These are matters for PIL.
Right to speedy trial. Under Article 14 years has already been allowed.
Defects have not been removed for over 6 months now. And the person aggrieved is not before the court. Consequently, the court is not inclined to entertain the present petition. It will be open to the person aggrieved, however, to pursue appropriate remedies in accordance with law.
Item number 66.
Dismissed with the above observations.
66.
Dismissed. No, non-prosecution.
Item number 67.
None appears dismissed.
Item number 68.
None appears dismissed.
No, my lord.
68.
Defects not removed for 8 months now. 9 months. For over 9 months, defects have not been.
Postal receipt, to produce already postal receipt filed.
Sorry?
Postal receipt filed, sir. Difference considers to be the government.
For over 9 months, defects have not been removed.
Might give 1 week time.
No. Court does not propose to grant any further indulgence. The petition is dismissed. Yes.
Item 69.
None appears dismissed.
Item number 70.
My lord. 69.
69.
69.
The defects not removed for a long time.
It is infructuous as the relief suffer has already completed.
Dismissed as infructuous. All right.
Item number 70.
Same thing for last more than.
That's what
6, 7.
They're not bothered about these things, sir. They're just burdening the court. None appears dismissed.
Item number 71.
Permitted to withdraw, my lord.
Counsel, the petitioner seeks leave to withdraw the present petition.
With liberty, but with liberty to file a better application.
With liberty to file a better petition. Dismisses withdrawn with liberty is paid for. All right.
Item number 72.
My lord, kindly allow 1 week time to remove text.
What's the matter? Encroachment made by private opposite party number 3 over government road.
My lord.
You filed a representation.
Representation is pending, my lord. Annexure 3 and 4.
Where is the proof of submission of representation? Where is that? That's not there.
Annexure 3, my lord.
Proof of service of the representation.
By hand they have given me. By hand they have.
That won't do, sir. Permitting the petitioner to make a fresh representation and after following up on such representation to seek appropriate remedies in accordance with law, the petition is disposed of. All right.
Supplementary for orders item 73.
None appears dismissed.
Item 74.
Same order.
Item 75.
Same time appearing in 73 and 74. On my mention has come, but SR has not been made.
That's right. And delay also, there is a huge delay.
Delay is there, my lords, I admit, but this is a peculiar case. Your lords may give me 2 minutes time.
What,
here,
sir?
my lords, here, my lords, the MCL, Mahanadi Coalfield Limited, acquires land on the basis of the principles laid down. Your lordship may turn to page 20 of the first read. I will not take 2 minutes. If you are not satisfied, your lordship may pass any order.
All right.
Your lordship may see page 20.
Yes.
What happens? Page 20 sub D. In case of families who have lost 1/3 of the total agricultural holding, one member from each family shall be provided with employment according to availability. According to availability, lords. That is the clause. What happened? We acquired some land in 1988 belonging to 4 persons. One Ishwar Pradhan, Jiban Pradhan, Deba Pradhan, and Lakshmi Pradhan. It was a joint property of 6 acre 8 decimals. Out of it, 5 acres some odd was acquired. One family, there was post we gave him. The other family filed a writ application that they have been given under the threat. We also gave them. But now that there is no other land, engagement is available, now they are going. We have given.
Yes.
Now, Millers, what happens? Under this, if we cannot give them employment, we can give them a monetary compensation. But now that Honorable Court has directed in the connected writ application, if your lordship will kindly turn to connected writ application, page 30. The Honorable Court, interpreting that clause, said this, they have interpreted this all, means you are bound to give the employment. So taking advantage of this, everybody, all the families are now threatening.
For appropriate case, you file it in time. So this is a delay of 458 days. It's too
yes,
huge.
we would have implemented. Your lordship,
we'll only say it will not constitute a precedent. That's all.
Yes. I'll be highly obliged.
All right. You see, there's an inordinate delay of 458 days in filing the present appeals, which have not been properly explained. Consequently, the court is not inclined to condone the delay, and therefore the delay application is dismissed. Consequently, the appeals are dismissed. Nevertheless, it is clarified that the impugned order of the single judge would be confined, would not constitute a precedent, and would be understood as having been passed in the peculiar facts and circumstances. All right.
Highly obliged. Highly obliged.
Item 75.
Blood, arising out of a minor mineral concession rules demand. A demand was issued based on an approximate calculation of the materials lying in the premises of a crosser owner. Now, I am not the lessee nor the permit holder. Under Rule 32, royalty is only by the lessee or the permit holder. Now, demand was raised against me. Lordship, kindly turn to page 28. Without any specific measurement, approximate quantity demand was a so cause notice was issued to me. I gave a so cause notice, page 28 of my writ appeal.
Condoned. All right.
Page 28 of my writ appeal, my lord.
Yes.
Then I gave a so cause that was rejected. In fact, against this rejection order at page 30, an appeal lies. But then the petitioner, I don't know with what advice of this court. Again, the registry committed the mistake. This was assigned to the division bench, page 52. Daro Singh Kumar's case will cover this case, my lord. That say the Chief Justice is the master of the roster and...
All right, we say notice state. Notice returnable. 1st February. There shall be stay of impugned order. All right.
Item 76.
76.
I'm sorry. I should have pointed out. 8 days delay.
I've condoned it.
Great.
Delay is condoned. Tell us what the matter is about.
I am for the OP, Union of India. 76, item 76.
You are for the Union of India?
Yes, my lord, opposite party.
We'll pass it over once. So 22 OP.
Item 77.
77, my lord, I have already removed the defect, my lord. And
limitation, sir. What is the limitation?
Limitation, there is no limitation, my lord.
139 days, sir.
No, my lord, 130. That is order passed in 22 to 2000. I have challenged the order dated 22 to 2022, my lord. In due time, I have already filed the writ application.
Steps for limitation not taken, it says.
No, my lord.
There is, please read the cause list, sir. So limitation, then defects 4B, 5D, 7.
Yeah, I have already removed the defect, man.
So you have to satisfy the registry, sir, not here like this. Defects we removed within 1 week. List thereafter.
Item number 78.
There is no limitation during COVID periods.
All right. Then on account of the delay being due to COVID, it's condoned and the application is allowed.
I am for the respondent.
The first day disposal.
Yes. No, limitation matter, no objection.
No. Disposal first day.
No, not.
No, that was remanded back and thereafter,
I see.
So
counter rejoinder, everything was fine. Thereafter,
all right. What is this matter about?
Page 39.
A copy of the read appeal.
I'll sir.
Yes.
This is not covered by that judgment. And also, my lord, I'll bring my lord's notice. First, he has approached this honorable court. There, my lord, he has said he's not covered by that resolution dated 17/9/2013. He to be covered by rule of 2013. That I have annexed that order. Earlier, he has approached the tribunal. Tribunal directed to consider his case in accordance with resolution dated 17/9/2013. We rejected it. Thereafter, he approached my lords. Your lordship passed the order on your lordship page 23. There, your lordship said he's not covered by that. You consider his case in accordance to 2013. Accordingly, we consider his case and rejected that.
Is that rehabilitation assistance?
No, not that is regularization.
Regularization.
So we rejected that at the page 25.
And he challenged this.
Your lordship may say page 23. Your lordship may see that page 23 for a moment. Last portion. Considering the submission with the authority directed to consider pets under the Odisha Group C and Group D Post Contractual Appointment Rules 2013. There, he said he is not covered under 2013 under resolution dated 17/9/2000. We consider his case. Accordingly, we considered and rejected. This was suppressed, and another case was filed. Your lordship, that is the subject of our challenge. There, he said he is to be covered under resolution dated 17/9/2013. Your lordship, may say page 34.
Both the stand was taken, my lord. And subsequently, my lord, this honorable court, when referred the matter, never said that you consider in terms of Rule 30.
Your lordship,
suppose I am covered under 2013.
Page 34.
I'll file counter, my lord.
Yes, here, my lord, a contempt has been filed, my lord.
All right.
No contempt has been filed.
Yes, contempt has been filed. Notice has been issued.
All right.
I'll not pursue the contempt.
All right, Mr. Tripathi. Notice, he accepts notice. Mr. Tripathi states that he will not pursue the contempt matter during the pendency of the present appeal. The statement is taken on record. Based on 16th February.
Supplementary item 79.
Date, my lord.
16th February.
What?
Item 79.
May I please?
Sometimes
doesn't make a difference. Yes.
And in the meantime, number of writ appeals, my lord, your lordships already disposed of and orders have been confirmed. If you also look at this, same view, my lord.
It's all right. We'll hear it on. Yes.
In compliance to the last order, we have filed the affidavit, my lord. This pertains to the blood transfusion that had happened. We have filed an affidavit on 10th of October, my lords. The affidavit must be on record. It's not on
the copy there.
I'll serve. Copy has been served, but I don't know.
Copy has not been served.
Copy has served on me.
The copy has been served.
I have received the copy.
Copy has been served. My lords, may.
No other person has
received the affidavit.
Me nor my friend.
My lords, 10th of October 2022. My lords, I'm giving the hard copies as well.
You've not got a copy?
I have got a copy. As a petitioner, I have been served with the copy.
Lordship directed copies to be sought on all, but it has not been.
Specific direction was copy to all.
No copy served on you.
No copies.
All right. Copies of the affidavit filed today in court by the state be served on counsel appearing for?
I am for OP number 8, the 8th society.
And you, sir?
I am for people 5 and 6.
All right. Counsel appearing for opposite parties 3 to 6 and opposite party number 8. All right. List on January.
Item number 80.
Your Lordship, I appear in item 80 for the petitioner. In the impugned judgment, page 7 of the impugned judgment, internal page, Your Lordship.
Yes.
My grievance has been noted down very clearly at page 7, bottom of the impugned judgment. Which if I may read, Your Lordship, reads like this, that this is a grievance. It is respectfully submitted that the petitioner could not be selected in the promotion, even though he secured more marks than the minimum cutoff, because as per the policy, a candidate must secure minimum of 35 marks in interview, otherwise he shall be treated ineligible for promotion. So, despite getting more marks than the cutoff, I was not promoted, not selected for promotion because I did not get 35% of the marks.
Who's appearing for the bank, sir? One Mr. Anand Rao was appearing earlier.
Yes, Your Lordship.
Mr. C.A. Rao. Should we pass it over or have it on some other day?
As per Lordship convenience, if Your Lordship can pass it over, all right. On any other.
Because it's already 1-5. That's what I was wondering.
Your Lord.
Okay, we'll pass it over once. Let's see. All right.
Most of.
Item 81.
Man appears dismissed.
Item number 82.
Item number 82. Just a minute. Mrs. S. Patnaik will conduct this case. She is not available today.
Oh, I see.
It may be.
So let them serve a copy. They have filed a compliance affidavit dated 22nd. Last time Lordship directed to serve a copy on the same day. It has not been back.
Okay. Copy of the affidavit filed on the previous occasion. Dated, what is the date? No? All right. By the state. Be served on Mr. Jena, now appearing on behalf of the petitioner. Ms. Patnaik, who appears for the state, is stated to be in some personal difficulty today. 3rd January.
In the second case for Union, we are appearing.
All right.
Item number 83.
Beg pardon, Your Lordship, my lords, I am appearing on VC, my lords. Item 83.
What happened, sir? That road is all right or not?
My lord, the road right now the road is in a motorable condition, but my lord, some major bridges have not been constructed till date, my lords. Around 4 bridges are there which are not constructed till date, and my lords, moreover, the crux of the matter is, my lords, within a span of 60 kilometers, the local lights have to pay 3 times, my lords. 3 toll gates there are. My lords, at least 1 toll gate should be stopped, my lords. My lords, it's beyond the public policy. It's hardly, it's tasking the people. Putting the
item 83, Mr. Umesh Chandra Mahanti is appearing for the other side. He has sought for one passover. He is in some other court. You'll also pass it over after lunch.
There will be no time, sir.
My lords, may kindly be taken up then tomorrow, my lords. I have some.
No. Later. Mr. U.C. Mahanti, learned counsel for the NHAI, stated to be in some personal difficulty today. List on 1st December, sir.
May I be pardoned to mention, my lord, item 81, my lord, on VC, my lord. I got disconnected in item 81, my lord.
Tell us.
My lord, in this matter, the matter was admitted on 13th of July, and the respondent were directed to file show cause response. It's a PIL for rehabilitation. My lord.
Management, give me some more time. I'll file my.
Or in 81, you say last opportunity to the state authorities to file reply within 8 weeks, rejoined for the next date. 9th February.
Oblige.
Passover items.
10th. You have to tell the people.
Passover.
Supplementary list pastor matter item number 6.
This grid code, I think, is very similar to.
Supplementary pastor matter item number 12.
None appears to better pass.
Supplementary list pastor matter item number 42.
None appears to.
Item 42, my lord.
42.
My lord, can it be passed over after lunch?
None. The counsel for the appellant is stated in some personal difficulty today. List on 18 January.
Pastor matter item 48.
Mr. Mishra.
I'm sorry, ma'am. Here, I'll have a very limited submission. In this sense, this matter relates to a regulation to 1956, whereby, by virtue of an amendment, the entire transaction from the year 1956 was sought to be revisited. Now, there are two kinds of forms to be filed by virtue of the amendment. One is 3A, which the authorities will initiate when they find somebody is in possession of a scheduled type property being transferred. One is 3B, the person files saying that I'm in possession, I have got the property. Now, this amendment has been held to be prospective by this noble court. Now, the original authority and the honorable single judge has proceeded on the premises that the civil court decree I have got is non-est in view of regulation 2. So, therefore, I cannot make any claim on the basis of that. Correct, man. I bow down. But the authorities, neither the honorable single judge nor the original authority, has been pleased to consider my claim with regard to 1954 acquisition, which only by virtue of a settlement record got changed. So therefore, there has been no determination. My prayer would be subject to your lordship's kind consideration that the authority should consider in terms of this decision where it has been held to be prospective, number one. Number two, with regard to my 1954 purchase by my predecessor, should be also considered, which has not been inquired into at all, except the civil court decree which I got subsequently, and they have said invalid. So that much I am praying for. I couldn't make copy.
In that event, there will be a remand to the single, because all these points are not considered by the single judge. And you have not raised all these points in the writ petition.
That is the only point, because this has come subsequently. 2019, this has come. A batch of cases were filed, and in fact, I had also argued this matter, but that matter was not tagged to this case, and it's not there. I had assisted the honorable court in this matter.
Then your lordship can remand the matter for fresh consideration in view of this judgment of the.
All right. And I was praying for to be considered by the original authority.
No.
Because if your lordship change it to the honorable single judge, also it will not serve any purpose.
Why? It can be
I'm not single judge. I'm only making.
No. I strongly object all this, because the single judge, honorable single judge will decide, because all these things are not to be taken into account by any administrative authorities. The judicial authority will take care of the decision of the honorable apex court.
The plea of the learned counsel for the appellant is that although it has been observed by the learned single judge. The civil decree obtained by the appellant in his favor is non-est in view of the Regulation 2 of 1956, the position that obtained prior thereto has not been taken into account. Full stop. In particular, he relies on the judgment in Jami Ramesh versus State of Orissa 2019 2 OLR 94, which holds that the Amendment Regulation 2000 would have prospective effect. Full stop. It appears that this issue was not considered by the learned single judge while dealing with the writ petition by way of the impugned order. Full stop. For the limited purpose, therefore, of considering of the above point, the court remands writ petition civil 15048 of 2005 to the board of the learned, to the file of the learned single judge by setting aside the order of dismissal of the writ petition. Impugned order of dismissal of the writ petition. Full stop. It is made clear, however, that the remand is only for the limited purpose of considering the above point and no other point. Full stop. Writ petition civil 15048 of 2005 will now be listened for judge for directions on 12th December 2022.
I was only praying one more thing. Malady, I may be
status quo passed by this order passed by this court on 31/1/2019 will continue during the pendency of the writ petition.
One more thing I was praying, subject to your lordship. I was submitting, leaving aside the civil court decree which the court has held honest, my claim that I purchased in 54 also should have been considered by the original authority and the honorable single. Original authority has not that much. If your lordship will not grant liberty, I'll have no case. But 54 purchase will not be applicable.
That means
I'll be only. It may be accepted or rejected. That's a different thing, my lord. The original authority, your lordship, page 29, your lordship will see it has not been considered also.
The applicability of...
He has only proceeded that the subsequent decree you have got is invalid. So I am only praying my original claim with regard to 54 purchase also may be considered, because your lordship will find that has not been considered either by
the appellant may agitate any other point before the learned single.
Right. The appellant is also permitted to agitate the issue concerning his purchase of the property in question in 1954.
54, my lord. That is preceding 56 came existence.
Yeah, preceding, which was earlier to the coming into force of the regulation of 1956. All right.
I'm deeply obliged, man.
Another
item 70. Item 70, I'm there.
Passed over, it was passed over.
Item 70, I was held in some.
Item 12 will also be
coming back after
non-appeal.
After launch.
That has been taken up. I was there and I missed actually, your lordship, and it was called again.
Argue it.
Item 6.
My lord.
Item,
may pardon,
my lord. Item 23, my lord, I am Sikh. So I pray an adjournment, my lord.
No, we're not adjourning anything, sir. We prepared to argue it.
Pardon, item 70, my lord. I was held up in some other court, maybe taken up.
We'll take it up. Let's finish.
Item 70, my lord.
All right.
Item 80, your lordship, I have informed the counsel for the respondent. Item 80, it was passed over, your lordship. Inform the counsel for the respondents in item 80, which was
It will be called out, sir. We are calling out the passovers one after the other.
Okay, sir.
Item 6 now.
May I please, your lordship? Challenges to the Honorable Single Judge's order dated 14/1/2016, your lordship, wherein the Honorable Single Judge has been pleased to dismiss my writ petition, praying for appointment on regular basis as a lady supervisor, when I am eligible and juniors to me have been appointed as lady supervisor on a regular basis. My initial appointment is 1993, Your Lordship, Annexure 1 in the writ petition. My Lord has the writ petition.
Yes, please.
My Lord, page 10, serial number 33.
Yes.
There I find place Kaushalya Pradhan, the appellant before my Lord.
Yes.
Now my grievances, Jharna Dhala, serial number 38. She is junior to me and now has been appointed as the regular lady supervisor. And in spite of posts being vacant, I have not been appointed as a regular lady supervisor, Your Lordship. Now the writ petition was dismissed, saying that this is a promotory post and need not be given. My Lord, may I just place a part of the impugned order, Your Lordship? Page 20, Your Lordship.
Yes.
Para 20.
No, read para 15. Para 15 and 16.
Para 15 and 16, Your Lordship. At page 18, Your Lordship. In order to appreciate the argument, may I place, Your Lordship?
I am asking you to place, sir.
Your Lordship, Your Lordship. In order to appreciate this argument, it needs to refer the notification dated 8/10/2007, which has been notified by the state government through its Women and Child Development Department in exercise of power conferred under Article 309 of the Constitution of India, named as Orissa Children and Women Welfare Service Rules 1989, and the same has been amended in the year 2007 by virtue of notification dated 8/10/2007 to be known as Orissa Children and Women Welfare Service Amendment Rules 2007. According to the said statute, the provision has been made to fill up the post of the grade of service in the manner provided therein, that certain eligibility condition which is provided under Rule 4 of amended Rule 2007 to the effect that an Anganwadi worker must have at least high school certificate or equivalent examination from Board of Secondary Education and rendered 10 years of continuous service on the first day of January of the recruitment year. Lordship, this eligibility criteria of having passed the high school certificate or equivalent and having rendered 10 years service is there with me, Your Lordship. The Lordship kindly sees. The Lordship,
continue reading, please.
Your Lordship. Thus, from the said statutory provision, it is evident that some posts of junior grade have been reserved to be filled from the Anganwadi workers possessing requisite qualification as indicated herein above. It is also evident from the record that the government, in order of smooth functioning, has come out with an executive instruction dated 29/7/2009, by which post of supervisor has been created on contract basis, and the provision has been made in the executive instruction having been issued by the Commissioner cum Secretary to the Government of Orissa Child Development Department to fill up the post of supervisor on contract basis, strictly on seniority basis, with the condition that from amongst the Anganwadi workers who have rendered their service at least for 5 years after graduation, with specific case of the opposite party is that the petitioner has never been granted promotion to the post under notification dated 8/10/2007. Rather, she has been given engagement as supervisor on contract basis in pursuance to executive instructions dated 29/7/2009. Since she is possessing the eligibility conditions as prescribed therein, now the petitioner claims to be regularized in the post of supervisor on the ground that she is possessing all eligibility condition as prescribed in the notification dated 8/10/2007. It is undisputed that promotion cannot be claimed as a matter of right by an employee. It has been held by a catena of decisions of the Honorable Supreme Court that promotion cannot be claimed by way of fundamental right, although its consideration has been said to be a fundamental right. But that too, if there is any violation of Article 14 or any discrimination having been caused to such employee, meaning thereby right to consideration for promotion will accrue when any person below in the seniority list would be granted promotion, ignoring the senior employee, then such senior employee has a cause of action for consideration for promotion. It is not the case of the petitioner that anybody who is junior to the petitioner has been granted regular promotion as a lady supervisor as per the notification dated 8/10/2007. But what she claims is that since she has been engaged on contract basis as supervisor, she be regularized. But that cannot be accepted because of the reason that admittedly, the petitioner has been engaged on contract basis as supervisor in pursuance to an executive instruction dated 29/7/2009.
Yeah. So how do you claim this regular promotion? On what basis?
My lord, the notification dated 2007, 9/10/2007, your lordship, that is annexure 2 to the writ petition. At page 14, your lordship.
Yes. Carry on, sir.
My lord. Section 6, your lordship, the posts in the junior brigade of service shall be filled up in the following manner. 30% of the total number of vacancies arising in the recruitment. My lord, may skip over.
This is all for regular appointment, sir.
My lord.
This is not for contractual.
My case is I have been wrongly given an appointment as a contractual.
No.
Has to be regular, your
that's too late to claim now. Once you accept the appointment, you're bound by it.
My lord, I was asked to accept it. I have
no question asked. Nobody put a gun on your head, please.
My lord, annexure 6, your lordship.
Yes.
Annexure 6. That's
yes.
The annexure 6 to my rejoinder at running page 41 of the writ petition.
Yes.
Now, this is to Jharna Dhal, the junior to the appellant, your lordship. I am directed to inform you that you have to resign from the post of Anganwadi workers in respect of your AWC, and in support of your resignation, the proof of acceptance of your resignation by the competent authority may be submitted to this office for issue of engagement order. Now, I have also been asked to resign and then accept this. That is my specific averment, your lordship. That was my specific averment, that I having been asked to resign and thereafter accept this post of lady supervisor.
There is no such letter issued to you. It's simply your averment, sir. There is no such similar letter issued to you as annexure 6.
That has not been denied.
Anyway, what else? Anything else? All right. A challenge in the present.
My lord, having rendered
Yes.
30 years of service as on date, your lordship is still continuing.
Correct. You say the challenge in the present petition is to an order dated 14 January 2016 passed by the single judge dismissing the appellant's writ petition civil 3321 of 2011. The appellant was claiming promotion as a regular lady supervisor instead of a contractual lady supervisor in terms of a notification dated 8th October 2007 and seeking from the date of her initial appointment, that is 7th January 2010. Paragraph. The learned single judge has rightly noticed the distinction between a contractual appointment and a regular appointment. Full stop.
May I, with one...
The appellant was unable to demonstrate, even before the learned single judge, that she had any accrued right of promotion on a regular basis, having been appointed on contractual basis. Full stop. Even before this court, the appellant is unable to point out on what basis such a claim is being made. Full stop. Consequently, the court is unable to find any error having been committed.
May I just, with my lord's kind permission, just make one small submission, your lordship?
Carry on, sir. We don't have time. Please carry on.
My lord, may kindly see order dated 24/2021, your lordship, passed in this writ appeal.
Yes.
Herein, my lords were pleased to direct the state government to take instructions if any junior to the appellant has been regularized in the meantime, which averment is there, your lordship.
It's all right, sir. It's all right. The appeal is accordingly dismissed. Right. Carry on.
Deeply obliged, your lordship.
May please, your lordship. But I have given a date chart, your lordship, for better appreciation of your lordship's fact. Lordship, may kindly see the date chart.
Yes.
On 9/1/1996, your lordship, the appellant and respondent number 3, two brothers, have jointly purchased 16 decimals from plot number 845. The share of Kasinath Swami by RSD number such and get the possession, and the said land was mutated jointly in favor of appellant and respondent number 3 by mutation khata number such and such. In the year 2002, an application was filed by the appellant and respondent number 3 under section 19(1) of the Whaler Act in the Court of New Officer Nimapada, bearing Whaler case number 453 of 2002, to make partition of the aforesaid land as proposed by both the parties in the said application, allotting Schedule A to respondent number 3 and Schedule B to the appellant, 8 decimals each, and to record the same accordingly in the name of appellant and respondent. 25/6/2002, accordingly to the Kacha Kharda mentioned in the application, the Revenue Officer Nimapada directed to record the Kacha in favor of respondent number 3 and Kacha in favor of appellant, and accordingly the ROR of Kacha allotted in favor of appellant was recorded in the name of appellant by ROR number 629/177 under Annexure 4, and on his application the said land was converted to homestead land by Whaler case number such and such under Section 8A of Whaler Act in favor of the appellant as revealed from Annexure 4 series and 5 years. The respondent number 3 filed an application before the additional Tahsildar Nimapada on 31/7/2003 under Section 60 of the Whaler Act to review the order dated 25/6/2002, wherein the said land was allowed to be partitioned among appellant and respondent number 3 on their consent on the ground of alleging fraud, your lordships. On 23/9/2003, the appellant filed objection to the said petition. On 22/10/2003, the Revenue Officer Nimapada allowed the review and set aside the order dated 2002 passed in Whaler case number 453 of 2002. On 30/10/2003, the appellant filed a writ application bearing WPC number 11,276/2003, challenging the order dated 22/10/2003 passed in the review petition, which is not separately numbered, but it is mentioned as the same number as Whaler case number 443 of 2002. 17/5/2010, your lordships, this honorable court was passed order in WPC number 11,276/2003, setting aside the order of review passed on 22/10/2003 in Whaler case number such on the ground that the party who is raising the question of fraud has to prove all the facts and the other party is entitled to adduce rebuttal evidence, and the revenue officer was directed to dispose of the matter afresh in accordance with law after giving both the parties adequate opportunity to adduce evidence in support of their respective pleas, meaning thereby the review application filed by respondent 3 in OLR case number 453 of 2002 has to be adjudicated. On 24/11/2011, though in the meantime the Tahsil of Nimapada was bifurcated and the land in question came under the jurisdiction of the Tahsildar GOP, the order dated 7/5/2017 was modified and the Tahsildar GOP was directed to adjudicate the review petition after giving opportunity parties to adduce evidence in support of their respective case. On 4/5/2016, pursuant to the order of this Honorable Court, notice was issued to both parties. On 25/5/2016, both the parties appeared and didn't produce any document in support of their claim. On 27/2/2016, both the parties were present but didn't adduce any evidence nor claim to adduce evidence. Therefore, both the parties were directed to file their written argument. On 22/7/2016, both the parties filed their written arguments. On 9/8/2016, the Tahsildar GOP dismissed the review application and the order dated 3/6/2002 was upheld. Thereby, the adjudication of review petition was closed on 9/8/2016 by the Tahsildar GOP. On 29/2016, the respondent number 3 filed a writ application bearing WPC number 1605 of 2016, challenging the legality propriety of the order dated 9/8/2016 passed by the London Tahsildar Revenue Officer GOP in OLR case number such and such, thereby dismissing the review petition filed by him and confirming the order dated 3/6/2002. On 3/10/2016, the Honorable Single Judge directed the State Council to take instruction as to whether in the meantime any final order is passed in OLR case number 453 of 2002 in terms of the direction of this Honorable Court, on the plea that in spite of repeated direction of this Honorable Court for the concerned authorities not taking any step in deciding OLR case, rather treated the application as review petition, rejected this. But fact remains that this Honorable Court by order dated 17/5/2016 directed to adjudicate the review petition and to decide the same. As such, prayer is made in the writ application, also challenging the order passed in the review petition. On 16/12/2016, order is passed by this Honorable Court directing the Tahsildar GOP to conclude the proceeding, providing opportunity of hearing the parties and passing a rescind order, while there was no proceeding lying before the Tahsildar after dispose of the review petition by order dated 9/8/2016 passed by the Tahsildar. Therefore, this appeal, Your Honor.
No. What is the single judge's order that you are not mentioned?
The order is, my lord, whenever, my lord, the direction is already by virtue of the order.
The single judge's order, sir, in your list of dates, you have not mentioned what the single judge has held.
He has to direct
Please read
my page 66, Your Lordship. Heard London Council for the petitioner and London Additional Standing Council for OP number 1 and 2. This matter was kept pending, directing the State Council to take instruction in the matter. Sri Das, London Additional Standing Council, on instruction from the Tahsildar GOP, produced a letter dated 23/11/2016 indicating the following the direction of this court. Both the parties were noticed to appear before the Tahsildar dated for further hearing. Since the Tahsildar is undertaking the hearing process, this matter stand disposed of, directing to the Tahsildar GOP to conclude the proceeding dated 30. Initially, it was in terms of the direction of the court dated providing opportunity of hearing to the and passing a rescind order. The petition is directed to cooperate with the.
So what do you agree with this order?
The fact remains that there is no proceeding, Your Lordship. Your Lordship may kindly see for a moment. There was no proceeding by the time. That is my grievance before Lordships. Your Lordship may kindly.
Your parties appeared before the Tahsildar and for further hearing.
That is a wrong submission, Your Lordship, made by the State Council. On the basis of that order was passed. Your Lordship may kindly see the review petition. Your Lordship may turn to page 62. Page 62, the review, hence Your Lordship may kindly see that order. What is the date? Date was 9/8/2013. Pursuant to the earlier direction passed by this Honorable Court under Annexure 9, the review, the respondent number 3 will adduce evidence, and the petitioner, the present appellant will review those evidences, and considering that, the review will be decided. That review will be decided thereafter. The matter ends there. Your Lordship may kindly see page 62. I have annexed that order.
No, this means this goes and it goes back to the Tahsildar. This proceeding gets revived.
Subsequently, my lord, it was decided pursuant to the direction of this Honorable Court. Your Lordship may kindly see page 62.
No, but if this is being set aside for a fresh hearing before the Tahsildar.
Yes, thereafter, my lord, it was decided. Your Lordship is correct. Whenever, my lord, direction was given by this Honorable Court under Annexure 9, That matter was remanded back to the Tahsildar. Again, review petition was taken up. And no person, both the parties didn't adduce any evidence. Thereafter, the review petition was dismissed. Your Lordship may kindly say, I have annexed
that order is gone, sir. The order dismissing the review petition is set aside.
No, earlier manner review was allowed. That was challenged before this honorable court. Earlier review was allowed. That was challenged before this honorable court. This honorable court set aside that order of allow and directed the petitioner as well as the opposite respondent number 3 to adduce evidence and rebuttal evidence, and that will be decided. Pursuant to that order, your Lordships, that review was dismissed. Your Lordship may kindly see, I have annexed that order.
What's the position?
My Lord, his case is that the impugned order suffers from error of record. He says that the proceeding was already concluded by page 62 and review petition stands dismissed. Thereafter, the Honorable Single Judge has said that you go and appear before the for taking action or for proceeding with the OLR case. But by that time, the OLR case is already disposed. I think this is the contention of this. But I don't know how the letter was produced by the Tahsildar that is pending. It is pending. 23/11/2000.
So this has to go back to the single judge?
Yes, it is to be go back to the single judge.
All right. It is agreed by both counsel that since the review petition before the Tahsildar already stood disposed of on 9th August 2016, there were no proceedings pending before the Tahsildar to be continued as directed by this court in the impugned order dated 16/12/2016. Paragraph, it is further stated again by both counsel that the statement of the then additional standing counsel on instruction from the Tahsildar Gop that open quotation, both parties were noticed to appear before the Tahsildar ... for further hearing, unquote, was an obviously erroneous statement made, as no proceedings were in fact pending before the Tahsildar. Paragraph, since the learned single judge has proceeded to dispose of writ petition civil 16605 on the basis of the statement, this court sets aside the order dated 16/12/2016 of the learned single judge, as well as the subsequent order dated 3rd January 2017. No, as modified by the order dated 3rd January 2017 and restores writ petition civil 16605/2016 to the file of the learned single judge to be heard afresh on merits. The said writ petition will list learned single judge on 15th December 2022. The appeal is disposed of in the above terms.
Because the single judge has not decided the legality of the impugned order in the writ petition.
Right.
He has simply remanded. Now it is to be decided whether the impugned order is dismissing the review appeal.
Correct.
Item 70.
Another matter was there, as a connected matter, that WPC PIL number 4124 of 2021. There was a earlier direction to Collector Rajput to...
Sir, defects have not been removed for how long?
For 6 months, around 6 months.
To say that let's come with the connected record. In the meantime, I will take steps for removing the defect.
Not so
that
late,
is
sir.
disposed of. That is
disposed of. You'll also see I've got a limited grievance. You'll also time to come to Annexure 1, page 15. Is the notification issued by Collector Jajpur for allotment of IFL on-soft. And as per provisions of statute by Annexure 5, the peoples of 3 different villages, adjacent Gram Panchayat, they have put forth their grievance before the collector at Annexure 5, page 61.
On-shop is now on for 2 years now.
No, earlier it was settled in favor of OP number 5. Subsequently, same was cancelled. Pursuant to objection filed by the...
How long has the on-shop been there?
Hello?
No, that license is for not
5 years.
like 5 years.
Forever.
Yeah.
So
on-shop, so far as on-shop is concerned. That earlier your lordship has dismissed. I'm just finding that order.
Given the certificate, not filed at the instance of the petitioner. It was filed by
maybe,
yes.
but same villager, same PIL.
Direction was
one or the other. If
direction was there. The collector Jajpur to look into the grievance of the petitioners till a decision is taken not to settle the IFL on SOP in favor of OP number 4. That was the direction. Despite that, collector Jajpur is sitting silent about the matter. I've got a limited grievance. Let by the next 5. The
but they have never
petitioners
for contempt. The petitioners of that
of
PIL,
three different villages, adjacent villages, they have repented to the collector Jajpur, OP number 5. Let him take a decision. That is what I have got limited grievance.
No, my response submission, it will only multiply the grievance petitions. If one order is already passed by this honorable court and you say that that order has not been complied, but the petitioners of that case, they have never approached for disobedience or contempt of the court's order. So I think what he is saying, that is not correct. That could not be. Collector must have taken a decision. Against another set of villagers, they are coming and filing. So there will be no end to the matter, my lord.
The collector is yet to take a decision. He is sitting silent.
Are you the lawyer of the petitioner?
No, somebody else.
Then how can you say so?
No, I have gone through that and I have.
No. What the collector has done in that other matter, how do you know?
How do you know? You are
I given the certificate, page 8, para 8 I have stated.
No, you have said that there is a case and it is disposed of.
Despite direction from to the collector Jajpur to take a decision based on the objection filed by the villager, that was never taken up care of by the.
When was that order passed?
It was passed on that
2nd of May, 2022.
2022.
Yes, my lord.
So you have to follow up on that, sir. Instead of filing fresh writ petition, there is already an order dated. Which is our order?
2nd of May. I'm sorry, my lord. He has given the certificate at page
8,
3,
para 8,
page 3 of the writ petition. 2nd of March 2020.
What was at page 8, para 8?
Yeah, there is already a writ petition civil PIL number 4.
Page 3 may kindly be certificate.
4124 of 2021.
Disposed of. All
filed by another set of villagers.
Yes.
Of the Gram Panchayat. Seeking similar directions as prayed for in the present writ petition. Full stop. It will be open to the petitioners.
It was disposed upon 2/3/2021.
It appears that the said writ petition was disposed of on 2/3/2021 with specific directions.
Para 8 as stated.
To the collector Jajpur.
Yes.
To consider the objections of the villagers.
Yes.
So it is now stated that the collector has still not disposed of objections.
It is alleged by the present petitioner, not the petitioner.
Let the state to obtain. I'm not on that. Let the state to obtain instruction. I'm not on the way.
It will be.
Let him take instruction.
Right. If the objections have not yet been disposed of, it is directed that the said objections will be disposed of by a reasoned order on or before 5th December 2020.
As you know.
My lord, the petitioners are not the objectors.
Yeah, those objections.
Okay.
The petition is disposed of.
Item 76.
None appears despite a password.
I am for the opinion. Item number 80.
I appear for the petitioner in this matter.
It is just informed by Mr. Sikera. Some of his relation has expired.
Oh, I see. Mr.
C. Anand Rao. For opposite
it is
party.
stated on behalf of that on behalf of Mr. C.A. Rao that he is in personal difficulty today. List on 20th December, 20 December.
Lordship, Your Lordship, in this case, unfortunately, the council respondent several times have been in personal difficulty or for some other reason.
What do we do, sir? What do we do? Try and expedite matters as much as we can. Right. Yeah.
16 special weekly list pattern, madam.
Don't repeat all that you have already finished. Only whatever is remaining you argue. All right. You already argued at length. We have heard you at length. Whatever is remaining, that alone you please argue.
I'll written.
If you have a written note, then we can ask him to reply. Because we have heard you at length the other day. So Katke, you can address.
Yes, dying declaration is dying declarations at Exhibit 5.
Correct.
Recorded by the additional Tahsildar Puri.
Right. Her only point was there's no doctor certifying that she's in a fit state of mind to.
Yes. That plus that your Lordship has already decided in 2 appeals.
And the second was that he himself went to save his wife and he injured in that process. That's the second point.
Yes.
He's also injured.
Yes. And here I'm just bringing to lawsuit notice judgment of the division bench of Honorable MP High Court. Of course, relied upon Lakshman, the case of Lakshman.
Lakshman is what the main judgment is.
Paragraph 38 starts with 38 and 40. In paragraph 39, Lakshman, the case of Lakshman was state of Punjab, Maharashtra,
right,
has been reformed.
That Jagbir Singh, again, they've summarized the whole thing.
I'll also give other Lordship as well as the judgments of the Honorable Supreme Court.
Right.
What is the copy? Copies? PW 15 at page 87 plus as stated, just plus I bring it to us. You must have gone through that deposition. She was in a position, the last line was the bottom. She was in a position to talk then.
Magistrate was saying so.
Magistrate. And inter deposition, even no cross examination has been made. In asking the Tahsildar, the executive magistrate, that in any way whether he is biased towards the accused. So he being a public official, and when no question of bias is there available, and even no question having been put to the Tahsildar, his evidence cannot be discarded.
Magistrate can say the person.
Why magistrate will be biased? Is a public official. That is solely submission, and on that also I will give other judgments of the Honorable Apex to a Lordship. That's the one, whatever I have.
All right.
Yes. May I file one short note of submission?
Yes. Do you have anything to say?
No.
All right. Orders reserved. Both parties are permitted to file their respective written note of submissions within 1 week.
Supplemental list for here item number 5.
May I please, Your Worship? This case, my lord, there are 3 appellants, my lord. The case, my lord, though the charge framed under section, my lord, 148, 302, 324, 149 of IPC, my lord, but the appellants convicted on section 302, 34 of IPC, my lord. 149, my lord, the prosecution not able to prove 148 of IPC, my lord, section 148 of IPC, my lord, for that reason the return of 302, 34 IPC, and also section 324. So far, one of the appellant is concerned, Sarathi Mahapatra is concerned, my lord. In this case, my lord, in fact, my lord, the officer in charge of a Bhuden police station received telephone call during morning hour on 20th 8 2000, my lord, regarding murder of 2 persons in the village. He made stationary entry. Thereafter, my lord, he left for the spot to verify the information. Who, my lord, the telephone the IIC, that is not during course of investigation, that is not ascertained by the investigating officer, my lord. When he reached at this spot, my lord, he found 2 dead bodies lying on the village road, and there was one Sonu alias Ramesh Mahapatra, son of one of the deceased, Anand Mahapatra, submitted a written information before the IIC, my lord. Thereafter, the IIC treated the same as a FIR and sent the same for registration of the case. Accordingly, my lord, the FIR, my lord, it reveals that on previous evening, that is 19/8/2020, one Kamini Mahapatra, who is the PW11 in this case, the wife of one of the deceased, Thakur Mahapatra, and aunt of the informant, asked one Sita Mahapatra, the wife of the Sarathi Mahapatra, for rupees 42 towards the credit taken from her shop. But Sita denied to pay anything, and a quarrel ensued between the two. At the time of accused Sarathi Mahapatra reached there, abused the family members of the informant and his uncle in obscene language. However, Ananda Mahapatra intervened and asked them to keep quiet. At this time, the accused Rajendra also came to the spot and asking Kamini, PW11, as to what money she was asking for, sure that he would do away with the lives of the members of 2 families within 15 days. On the next day, at about 6:30 a.m., Thakur Mahapatra, the uncle of the informant, was going to his field to canalize the water. Near a canal at a Matkani square, the accused Rajkumar, seeing him, asked as to what money he was asking the previous night and dealt a blow by means of a kodi spade on him, as a result of which he fell down on the ground. Hearing shout, by the time nobody was there, my lord. Only one of the appellant is present and one of the deceased is present. Hearing shout, Amini Mahapatra and Jayanti Mahapatra, PW11 and PW14, my lord. The aunt and sister of the informant respectively reached this spot. At this time, the other 4 accused persons reached there, being armed with a knife and a gupti, and started assaulting Thakur Mahapatra and Anand Mahapatra, who also reached there. They dealt blows by means of knife, spade, and the gupti, causing severe bleeding injury, to which both the brothers succumbed at the spot. When Kamini tried to intervene, she was sustained a cut injury on her palm. Getting the information, the informant reached at the spot and ascertained the incident from his aunt and submitted the report to the police after their arrival. At this, As it further revealed from the evidence of two eyewitnesses, the accused persons threw the spade at the spot and went away, giving out a threat that whatever would give evidence against whoever would give evidence against them, they would kill him, and their clothes were also bloodstained. In course of the investigation, the inquest was conducted over the dead body, and those were sent for a postmortem examination. Witnesses were examined, and spade left behind at the spot was seized. The police officer, on return to the PS, found that two of the accused persons, namely Sarathi and Rajendra Mahapatra, were present at the police station and had also submitted an FIR against the family members of the deceased persons, which was registered as PS case number 50 dated 20th 8 2000 under 341, 324, 294, 34 of IPC by the SI of police in absence of the OIC. The IO arrested said two persons and seized their wearing apparels. While in police custody, the accused Sarathi Mahapatra confessed his guilty and led the police and a witness to recover the Gupti concealed by him at his village, which was seized by the police. The accused Dhulu Mahapatra, since dead, was arrested from village in the same night, and the accused Raju Rajkumar was arrested on the next day of the Bhuden day at a Bheden CSC after he recovered from his injuries sustained by him. On the following day, the other accused Sagar Mahapatra was arrested. The injured Kamini Mahapatra was also medically examined. The postmortem report were obtained. The opinion of the doctor was also obtained regarding the weapon of offense. The seized materials were sent for a state forensic laboratory Bhubaneswar for test. And after completion of the investigation, the charge sheet was placed against all the 5 accused persons under section 147, 148, 341, 294, 302, 324, and 149 of IPC. However, charge was framed under section 148, 302, 324, 149 IPC against all the accused persons. In this case, all the accused persons, my lord, pleaded not guilty and faced their trial. The plea of the defense was a complete denial. A further plea was advanced on behalf of the defense that the murder of 2 deceased persons did not take place at the time and place as alleged, and that their dead bodies were simply brought to the spot, and the case was got up against all the accused persons by implementing materials and by creating witnesses. The prosecution examined 18 witnesses as against one.
No, just don't go on reading, sir. You make your point.
I am, my lord, coming to the findings, my lord.
Yes.
Findings, my lord. That the 16, the accused person, namely Raju Rajendra and Sarathi, jointly did blows. But the specific allegation, there the accused finding of the court, page 16 of the judgment.
Right.
The 3 accused persons, namely Raju, Rajkumar, Rajendra, and Sarathi, jointly did blows on both the deceased by means of spade, knife, gupti, causing severe injuries on the vital bodies, which caused instantaneous death of the 2 brothers. Insides, penetrating and lacerated wounds were found by the doctors on the bodies, and the injuries were antimortem in nature. Thus, the common intention of the 3 accused persons would have been nothing but do away with the life of the 2 persons. Taking into consideration the fact and circumstances of the discussed, I am of view that the prosecution sufficiently proved the offence under section 302, reduces 34 of IPC against 3 accused persons. Further, up to 24 of IPC was also proved beyond doubt against the accused Sarathi Mahapatra. So in the result, therefore, the trial court, while acquitting the accused Sagar Mahapatra, all the charges and setting him at liberty, the other 3 accused persons also acquitted from the charges 148 of IPC.
The accused persons, namely Rajkumar, Rajendra, and Sarathi, are found and held guilty for the offence punishable 302, 34 IPC and committed thereunder. The Sarathi is also additionally found held for the offence 324 of IPC is convicted thereunder, my lord. So far the case is concerned, my lord. In fact, the OIC, he received a telephoning message while he was in a police station and came to the spot, my lord. By the time, none of the family members nor the villagers lodged any information or telephoned the OIC, my lord. That after, my lord, the FIR lodged by the son of one of the deceased, my lord. Though that was inscribed by one Prashant Kumar Mahapatra and lodged by Pidol 1. And the evidences of the two doctors, my lord, Pidol 12 and 13, my lord. I want to praise their evidences, my lord, because, my lord, the
is 79. PW
1279.
The postmortem exam is conducted in respect of the deceased Thakur Mahapatra.
12. On 20th 8 2000, I was surgery specialist headquarters hospital Burger. On the same day, on police section, I conducted examination on the dead body of Thakur Mahapatra, son of Tikelal Mahapatra of village such and such. The body was scout male, aged about 45 years. Rigor, merit, mattage present over all the limbs, eyes closed, mouth half open, 40 bloody coming from nose and mouth. Following external injuries were found on the person. There are, my lord, 7 injuries. He stated there are 8 injuries. All the injuries are antemortem in nature. The cause may be due to asphyxia, caused due to penetrating injuries to lungs. Time since death was within about 24 to 30 hours. Time of examination 5:30 p.m. on 20th 8 2000. Exit 14 is my report and exit 14/1 is my signature. My lord, here, my lord, what happened? Though the IO, the postmortem doctor, Pidol 12, specifically stated that the cause of death may be due to asphyxia, cause of penetrating injuries to the lungs, my lord. There are 2 eyewitnesses, my lord, examined this case. Though the independent witness Pidol 15 does not support the case, my lord, but he not support the prosecution case. But Pidol 11 and 14 is the daughter and a wife of the one of the deceased, my lord. They have supported the case, my lord. In fact, my lord, the postmortem doctor has not mentioned in the postmortem, though the only one injury, that is injuries, penetrating injury to the lungs, my lord. None of the eyewitnesses, my lord, though they are interested and family members of one of the deceased, my lord, they have not stated, mentioned anything who caused the lungs injury, my lord. That is totally absent. That type of, my lord, doctor who conducted postmortem examination, my lord, he has not stated whether the death is homicidal or not. The opinion or not there, my lord. Finding is not there whether the homicidal nature or suicidal, since the death is due to asphyxia, my lord. That is there, my lord. Like this, my lord, Pidol 13 also, as page 83, cause of death, another disease. Cause of death is due to shock, due to injury to heart. Time is death 24 hours of my PM examination. The time of examination is 4:15 PM on 20th 8 2000. Exit 15 is the report and 15/1 is my signature. So he stated also, stated in his examination chief that death due to shock due to injuries to the heart. Nobody, none of the witnesses, 2 witnesses are examined as they stated that there are the eyewitnesses to the occurrence. They have said against any of the persons, though they specifically stated that one of the accused asserted to the head and another accused asserted to the head, but specifically not who caused the injury on the heart of the one of the deceased and injury on the lungs of the deceased. But that is absent, totally absent. Another thing, my lord, my lord, How much longer will you take?
My lord, it will take, my lord, since double murder case, my lord, I
Will continue on Monday.
Monday, my lord. Monday, my lord, next Thursday it will better, my lord.
No, Monday.
My lord. My lord, take some time at the quantum law is required, my lord, see case. My lord, okay.
Just partner.
Item 86.
Your Lordship. My lord. My lord, may I kindly permit me to take another copy of the paper book, my lord, in 86. Because
You can get it in the soft copies. No problem.
my lords, grateful.
Just collect it.
Item 87.
17.
Item 88.
87, my lord, I am here for.
24. You have to get up early.
There are so many appeals. I am for criminal.
Early, giving you a date.
Item 89. Item number 90.
Lordship, in item 88, your lordship.
Just get the dates from the book.
89.